Dear Lordship, indulgence, mention item 12. In this matter, my lord, we are supposed to file two applications, one for amendment in the pleading, and one for, my lord, infringement of some other respondents. Now, my lord, my client sent only one petition and another petition he did not. So can I pay for 2 weeks' time so that we can file both the petition at a time?
My lord, I pay for phone number 1 here.
This is an old matter. Old matter. Just 2 weeks, my lord, so that I can file both the petitions.
What is the represented? On the clear made by Mr. Isletter and the senior counsel for the petition. Just again after 2 weeks.
Lord, may I pray for a date, my lord, in this case, if possible?
Okay, just collect it after some time.
My lord.
My lord, the interim may continue.
If you want to pass this and extend it to the next check.
Okay.
Okay, please collect it after some time.
I pray for listing of a CRPI.
Listing, request please give it to the court faster.
That is lost.
No, I can 52 of supplementary causes lawsuit. In this case, my lord, subject is already, my lord, complete, my lord, respondents appeared. So I have consent of the respondent's lawsuit. May I pay for 2 weeks lawsuit? I am filing an amendment petition law.
Amendment petition.
Lawsuit.
Service is complete.
Oh, sorry, Lord.
Service is complete.
Yes, Lord.
But why it has come for orders then? It has been brought by
Why it was
orders.
not listed for orders lawsuit?
Somebody has mentioned it and brought it
I
back.
mentioned lawsuit because my lord, the returnable date was over lawsuit. That is my lord. Interim order was in the lawsuit.
Just wait for some time. Let me get the records. Just wait for some time. We'll get the records. So next.
Yeah, please, Lord. I wish to mention item number 6, my lord. Item number 6 may be taken next Monday, my lord. I have to do some accommodation, my lord.
6.
Yes, my lord. Next Monday. My lord.
The where we can proceed for the petition based on 25/5/2026.
I'm making a prayer for listing of two matters. Day after tomorrow, madam.
We can't say because there is
Or I beg to mention item 21, can the matter be passed over for the day? Item 21.
okay. Here made by Mr. Paul and counsel for the appellant. This password for the date.
Oh, bless.
May I please, Lordship, I beg to mention for item number 29, Lordship, order column, Lordship,
Therefore,
petitioner, Lordship. On the last dated, Lordship, the affidavit in opposition filed by the respondent was not in the record, Lordship. It has been come in the record, Lordship. But the matter is come into the order, Lordship.
so let it be. It's a transfer petition, doesn't matter wherever it is listed.
Today, we are seeking for the adjournment, Lordship.
Why in a transfer petition?
Lordship, my senior is out of session for some difficulties, Lordship, personal difficulties, Lordship. With the consent of the other party, Lordship.
Consent of the consent of the other side, the counsel for the petitioner, pays for the adjournment, there is allowed. This on 22/5/2026. Yes. Yes.
I think you need to attend the 14. Okay. Also, in this case, noted, compromise going on.
14.
Get it up. Okay.
14.
I am appearing for respondents in this case.
Is there a mediation going on or are you just talking for compromise?
Talk of compromise. Only.
Why don't you have mediation?
Lordship,
This,
may postpone the matter after 2 weeks, my lord. We are trying to settle amicably matter.
Okay, both sides are represented. It has been jointly submitted by the counsel for both sides that talk of compromise is going on. Accordingly, matters stands adjourned today, list after 2 weeks.
Lordship, it may possible, Lordship, after 4 weeks, Lordship. After 4 weeks, Lordship.
4 weeks.
Lordship.
And highly will.
Lordship, they are the interim, Lordship.
If you want to pass the list and it ended in the next bit of this thing.
He would.
Please, Your Lordship, I beg to mention item 19, Your Lordship. The conducting counsel is not available, Your Lordship.
This after a week as straightforward and counsel for the petitioner.
Madam, item number 11, madam. Item number 11.
Yes.
There is some mistake in the annexure 1. So I may be permitted to correct the mistake.
Annexure 1.
Yes, madam. Instead of the copy of plain, the copy of a petition was annexed. So I may be corrected.
Okay. And the prayer made by Mr. P. P. Das and counsel for the petitioner is permitted to we can record the appropriate document as annexure 1. The corrections, the needful shall be done in the presence of AOJ. You will revision section.
Yes, madam.
And thereafter the matter will be listed again.
And that may be fixed, madam. For
Once you do the corrections, we come.
May it please, Your Lordship, I beg to mention item 18, Lordship. Lordship, we have filed additional affidavit along with one substitution and condonation that may be kindly called from filing session, Lordship.
Condonation application, then it has to go to another date. The legal counsel for the appellant permits that application for substitution
Substitution and condonation.
and application for condonation of delay has been filed. Registry shall track the same and list the appeal along with the applications on this Friday. This will be the Friday. 22.
Item-
26.
Lordship, also I beg to mention one RSA for listing
Listing give it to the court master.
of life. May it please, Your Lordship, I beg to mention item number 40. Your Lordship, my senior.
40.
40. Your Lordship, my senior is currently out of station, therefore let the matter may be adjourned.
From 22. 522, that's paid for by non-counsel for the petitioner applicant. Yes. Okay. 52 we can record.
52, prayer for adjournment.
Taking consent of the other side.
Yes, ma'am.
Take both sides of the petition on the prayer made by non-counsel for the petitioner is on. After 2 weeks and deadline. We date after 2 months. Any date may be fixed. Okay, is there any date after some time? May be confirmed. Thinking about a past of this, and extended till the next date of this. All right. All right.
For motion, item 1.
Legal Lordship. My lords, this KRP IO has been filed basically challenging two orders. One order is page 16. And another order, page 60. Now let us see first page 16.
Where is the copy of plain?
Hello?
Where is the copy of plain? Plain.
Copy of the plaint. Yes, we have annexed. That is page 58. Sorry. Page 42.
This is a provisionalized school.
Yes.
In provisionalized school, how can you maintain a suit? The staff was, they were ordered first against the defendant number one.
Provincial school, no doubt, but thing is this, my lord, the school's name has been changed due to unknown reasons. For instance, kindly see page 17. The school's name is B.R. Milan High School, Fukuatapa, Post Office, Rauli. And page 70, kindly see, to the headmaster in charge, B.R. Milan High School, Fukuatapa. Regarding mentioned full school address in the signboard and other official papers in respect of your school. With reference to the subject cited above, I would like to inform you that an allegation is received from 237 members of public of Fukuatapa village who are stated that you have not mentioned the full school address in the signboard and other official papers in respect of your school. Therefore, you are instructed to mention the full address of the school in the signboard.
How will the suit be maintainable for that? It's an order passed by the inspector of schools. How can a suit be maintainable?
Maintainable, my lord.
Official acts are said under Constitution here.
Earlier, there was a title suit. Title suit was retired. And in title suit, there were
Please tell
seven.
me how a suit will be maintainable against official acts. The inspector of school passed an official order.
Yes.
How can against that suit be like?
No, that is my question also. That is also my question. Kindly see page 17. This order is passed on 17/4/25. School's name is written, the headmaster in charge, B.R. Milan High School, Fukuatapa. So it was directed by the IS to the headmaster that you mention the full name of the school. Now, impugn order, kindly see now page 16. First order is dated 17/4/25 and second order is 14/11/25. Just after 5-6 months, this order is passed. This order is passed, operative portion may be seen in third para. Under the above circumstances, the inquiry committee recommended that in the interest of public, the school name be renamed unchanged, that is B.R. Milan High School, Post Office, Rauli, District, Barpata, established in 1976. Now, this is our also question that after 5-6 months, why this order has been passed? Now, second thing,
I'm asking a simple thing. How would a suit for declaration lie against the official government orders? You are the plaintiff. You are the plaintiff. Please tell me, I'm asking only one simple question. How would a suit lie against the declaration lie against the order of an inspector of schools?
here is two types of things are there. One TS, that is returned. That is one aspect of the case. Now another petition, if you see highest order, it lies to writ petition. But now question is this, there are two dimensions. One is passed by civil court, another is passed by government authority. But basically the civil suit was filed directing the authorities to mention the full name of the school along with the address where the school is situated. The school is situated at Bukataba village. There is the circle officer certificate. We have also annexed that. Kindly see,
I'm giving a very horrible example. The Cotton College address is at Pandija.
yes,
The authorities say that you will write, what you call this, Pandija at, not in Gauhati, but Kamrup Aminggaon. They pass an order. Rightly or wrongly, they pass an order that, this Cotton College address would now be Cotton College, Pandija, Aminggaon. How does the suit lie?
well, question is this here. If you see the order of IS, then writ petition lies, in my humble opinion. Secondly, if we see the order of the landed munship,
Withdraw the suit and come to the High Court. How will the suit lie? How will they entertain a revision petition?
but that was, well, as kindly see the court's order, that was some developments are there. Kindly see page 69. Submits that he wants to withdraw this civil division petition and prays for derivative file afresh. The prayer of Mr. Mahmood is allowed. The civil division petition is disposed on withdrawal with liberty to file afresh. Now, fresh, we have since we have mentioned the grounds here. Why this petition has been again filed?
Mr. Mahmood,
Never.
please tell me, I'm asking a second question. Is this revision not a wastage of time of the court? Your claim was returned.
Yes,
Your miscase was returned.
yes.
And now you have filed a division. And you are not challenging the order of return of claim. There is
Return,
no suit and you have filed a revision.
return of the suit.
Just tell me how much cost.
Return, that is true. That is why you have
How
come
does
here.
division lie? How do we get jurisdiction under either 115 or 226?
1155. Well, as I understand, 115B says the learned court did not exercise its jurisdiction properly,
Return
And-
of the plate was not exercised property.
or has exercised the jurisdiction, but in a wrong manner. Now we have filed a case, seeking injunction that the name of the school should not be changed. So that was, if there was any mistake, then amendment petition may be also filed.
Without filing section 80, you file a suit.
Yes.
Plate was returned and you say that you should be given an opportunity to amend the plan.
No, 80 was, that is for waiver of the notice. But that was not properly filed. I understand that. After 2 months it was not there and proper plaint was also not there. It was hurriedly filed by the lawyer in court below. So here I have, at the earliest time introduction, I have said that if we see the order of IS, then writ lies. If we see the order of the landed munship, then CRP lies. Now that is my humble understanding. It may be wrong.
Okay, don't entertain.
Now, if your lordship kindly give any
This not right.
option,
This division was not right.
but this revision came several times to several courts, my lord. They did not raise the issue. So that's why I do not say.
I'll tell you one thing. There are 1,000 judges in the country. You want all of them to act mechanically that one view taken by one court should be taken by all courts.
That is not the law. Exercise of mind is also.
So therefore, I'm asking you a question.
Very well, lordship.
Merely because the revision was entertained by another honorable judge. In his wisdom, he deemed it fit to entertain.
Then your lordship may pass appropriate sort of with that we may take appropriate forum, appropriate.
Mr. Elio Mahmood, Prime Counsel for the petitioner. Also heard. Learned standing up for the education department.
Education.
Representing
Response 1, 2, and 4.
Respondent number one, two, four. Okay, I did not hear you. You want this to be admitted and heard?
Lordship, the same issue was raised by another honorable judge, Lordship, on the previous occasion.
No, but what do you say?
Lordship, it is not maintainable, Lordship. They should have filed a writ, Lordship.
No, that was not, but another court was not that view.
okay.
Learned friend knows this.
Okay.
So how many cases we will file?
Next one. The petitioners as plaintiffs had filed a civil suit agreed by orders passed by the
IS Borbata.
Inspector of Schools, Kolkata District, Kolkata. By which the headmaster in charge of B.R. Milan, MILN High School was requested to maintain the school address as recommended by the inquiry committee referred in the said Tribune order dated 14/11/2025. In the claim, the pair was for a decree for declaration for cancellation of the Tribune orders dated 14/11/2025 and consequential order dated 6/11/2025. No, sorry. 6/11/2025 and order dated 14/11/2025. And for a declaration to continue the address of the school as village.
Hukuatepa.
BHAKUATEPA in the record of the school. For maintenance of status quo, for permanent injunction, etc. The Unit trial court IUP Court of Unit Civil Judge within bracket Senior Division bracket post Kolkata. The impugn order dated 21/11/2025. Returns the claim to the plaintiffs on the ground that no notices as per section 80 within bracket 160 was issued. And that the plaint did not contain a single word to show the nature of seriousness and urgency. By a separate order passed on 21/11/2025, the proceedings of Ms. J case number 238 of 2025. Earlier order is at case 60, 21, and the next order is at 60, sorry, 62. Return the said Ms. case to the petitioners. Agreed by the said orders dated 21/11/2025 by which proceedings of PS 132 of 2025 were done, and order dated 19/11/2025 by which Niji case number 238 of 2025 was returned, and to assail the order dated 17/4/2025 passed by the Inspector of Schools from Barpeta District Circle from Barpeta, by which instructions were issued for the name and address of the school as D.R. Milan High School from Gauhati, GHATUAPEPA. The present review and petition has been filed. Mr. Mahmood, I am putting you to notice that in the event we dismiss this revision on merit with annexure 1 being challenged, then you will be, for all times to come, you will be precluded from challenging this annexure 1. Because this decision of ours would be a final decision. You want to exercise option to withdraw this
No,
petition?
withdraw with liberty to file a proper petition. Not on merit.
As apart from issuing the interim orders that is 12/11/2025, the challenge is always also made to order that is 14/11/2025 by the Inspector of Schools from Barpeta District Circle. The court has put the learned counsel for the petitioner to notice that if the division is decided on merit on the Inspector of Order dated 14/11/2025, it would preclude the petitioners to make any further challenge to sale before any court. Accordingly, the learned counsel for the petitioners is invited to withdraw this petition and to approach again in an appropriate manner. In this fact, this is final article 227 of the Constitution window. Dismiss on the job, if liberty is paid for.
Liberty has granted.
Item 2.
Item 2,
Yes, this will lordship. This is as per petition lordship, 37/25 is pending before Sonitpur Court lordship. Now she is living at Dibrugarh lordship, so she is facing very difficult lordship. Therefore, she wants to transfer this matter to the Dibrugarh lordship. And I, for say of the proceeding lordship, will transfer.
You want the transfer from Sonitpur to
Dibrugarh lordship.
Dibrugarh.
She has minor child also, so she
But Ms. R. Borobora, and legal aid counsel for the petitioner. Next, the petitioner, who is the estranged wife of the respondent, is seeking transfer of matrimonial proceedings being PS within bracket M, bracket close number 37 of the 2025, along with BCA case number 25 of 2025, pending before the learned district judge, Sonitpur, Tejpur, to Dibrugarh has a family court.
Dibrugarh, I do not know. Any competent court at Dibrugarh?
No, these things can be written in the order.
Lordships, as per internet lordship, Kamrup Metro 3, Kasar 1, Borpeta 1, Kudri 1, Nalbari 1.
That's what we are looking at. Family court is not there.
Lordship.
It's not there. To the Court of Honorary District Judge, Dibrugarh. The reason assigned for the transfer is that the petition is to take care of a minor daughter found on 30 9/6/2021. And she's a poor lady without any source of income and dependent on her parents, and she has no one to accompany her. So, Dibrugarh to take to attend the court proceedings. Next, issue notice returnable on due date after 4 weeks. Returnable so and so. The district shall take steps within 2 days for service of notice on the respondent by speed post with AD. Next up, with the next returnable date, the further proceedings of PS within bracket N number 37 of 2025, pending before the learned district judge, Sonipur, Telugu shall remain state. Next, the petitioner shall produce a certified copy of the order before the said learned court issue the order to the notice of the said learned court. What is this, IA form?
IA for stay lordship, stay of matrimonial, title suit number 3725 and Ms. J case number 2525.
It should be connected miscellaneous proceedings. Okay. And then, while issue notice, you also say issue notice in this transfer petition along with notice in IA Civil 1601 of 2026.
If you bless him.
Item 3.
Wait, Peter. No, in this case, we are assailing an order passed by the District Council Court, Miller. Now, the claim of the opposite party is not supported by any material, any evidence, my lord. Yet, my lord, the court passes an order in favor of the. Lord, if your lordship would kindly come to page number 134, that's the impugned order.
I'm just asking you, since this relates to, I think, mutation orders.
Yes. Yes.
Traditionally, from the appellate order,
Yes.
You go to Board of Revenue. In this, Board of Revenue would not like.
Milord, no, Milord. This is under the District Council.
We understand.
That's why.
Because the
Otherwise, yes. Milord, basically not against the mutation order, Milord. Now, in fact, the right title and interest of the opposite party has been declared to the extent of half of the property. And it, yes, please come to page 135, Milord. Or other 136. That the parties to the case belongs to Dimasa community and NC Hill Autonomous Council Court is constituted under 6th schedule of the Indian Constitution and to operate primarily to administer justice based on traditional tribal customary law.
From where, Mr. Chaudhary?
Yes, Milord.
You're reading from where?
Page 136, Milord.
136, yes.
Yes.
Oh,
From
the case,
top.
no, from the top. Yes,
Yes.
yes, please continue.
That the parties to the case belongs to Dimasa community and NC Hill Autonomous Council Court is constituted under the 6th schedule of the Indian Constitution and to operate primarily to administer justice based on traditional tribal customary law. Now, according to Dimasa Kasari customary law, Chapter 4, Law of Inheritance of Properties from Parents are as follows. Land, house and household properties, both movable and immovable, are heritable
land are male owned properties, female owned properties like looms, ornaments, gold, silver, women traditional clothes, etc. Male properties are inherited by son more or less equally. The youngest son may not only inherit larger share of the property, but also assumes the responsibility to maintain and look after his aged parents. Late Hamdon Mohan Haflongbar and his wife Desainidhi Haflongbar were looked after by late K.K. Hozai and his wife Urmila, father of the petitioner, father and mother of the petitioner. All medical expenses of ailing parents were borne by K.K. Hozai and his wife. Where his daughter do not inherit any landed property. However, if the father is desirous of making a will to give right of the land property, paddy, etc. to his daughter. However, under chapter 6, clause 2, clause 2, point number 7 has a provision that when a father dies intestate, all his movable properties will go to his son and daughter more or less equally. In the instant case, there is no such will or gift deed. Left behind by late Hamdon Mohan Haflongbar, resulting to dispute over the claim of property and hence approach the court of law for justice. Thus, the Honorable Court of Judge, having regard to the nature of the land from the aforesaid extract, is clear that the land originally belongs to late Hamdon Mohan Haflongbar and his son and daughter, namely Hemendra Haflongbar, son, and Urmila Hozai, daughter, were not alive. In addition, the land is not testamentary. Hereby, the Honorable Court, as per provision of the Dimasa Customary Law of Inheritance under clause 2.7, chapter 6, divides the disputed property equally, 8.5 each to the appellant and respondent, being legal heir of the Urmila Hozai and Hemendra Haflongbar, that is that Kumud Hozai, that is the appellant, that is the petitioner, and Sukla Haflongbar, respondent, out of the 17 kathas. My lord, sort of an panchayati thing has been done, my lord. Now there are late Hamdong Mohan Haflongbar, my lord. He had 4 sons and 2 daughters. Now fight is between one, my lord, nephew and maternal auntie. Now the issue is, my lord, first my point is, my lord, it's a case that it is hit by the principle of non-joinder of necessary parties. Number 2, my lord, what is the evidence? And there is a patta in my name. And the appellate court admits that the one who looks after the parents, he will get a major share. And in fact, my father and mother looked after both my Hemdong and wife Srimati Desainidhi Haflongbar. Now, on what basis, my lord, there is a declaration in favor of the opposite party? There is no will, no nothing. On the contrary, there is a patta in my name. My lord, then how to, if you have to cancel the patta, you have to go to the revenue authorities. How can civil court do that, my lord? I can appreciate, my lord, if there is a registered sale deed, if it comes to setting aside a sale deed, then a suit may lie. No, my lord, it defies logic. Who has proved whose case, my lord? Who has? Section 101 Evidence Act has been given a total go by.
Customary court, that is not required.
Yes. Or at least spirit has to be followed, my lord. And I was not given any opportunity of cross-examination. We have taken all the points. Now, my lord, kindly see, the subordinate court declares 4.5 kata in favor of the opposite party and rest to me. And, my lord, now the appellate court divides it equally between 8.5, 8.5. Based on what? Admittedly, the opposite party's husband is not the youngest son. Youngest son predeceased, my lord, him. And there is at least evidence that my father and mother looked after my grandfather and grandmother. And as per the customary law, in fact, my lord, in recognition of the service, entire property was given to me. That is how there is patta. If your lordship would kindly come to, my lord, page number 34, my lord. This is the periodic patta, my lord. In respect of the entire plot of land. Whereas you, Sumud Hozai, son of late K.K. Hozai, are in occupation of a plot of land in Haflong, in the Mahasau, measuring 17 katha, bounded in detail, so and so, so and so.
And where is the original court order?
Yes.
Original court order is at page 69, Miller. That is more interesting. Please come to page 71. Page 71, Miller, somewhere in the middle, now sentence starting with now court being a tribal customer, it has a lot of that. Page 71. Exactly in the middle, there is a paragraph starting with the word now the court being a tribal. Yes. Now the court being a tribal customary court of Dimahasa gives verdict on the basis of tribal customs and laws. In the present case, as both the parties cannot produce solid evidence proving that Hamdan Mohan Haflongbar had passed on his property to which party, the court shall take Dimasa customary law as base for giving verdict since both the parties belong to Dimasa tribal group. The court of just subordinate hereby declares the verdict has gone in favor of Srimati Sukla Haflongbar, that is the opposite party, as she is the legal heir of late Hemendra Haflongbar, who was the son of late Hamdan Mohan Haflongbar, the original owner of the disputed land. However, the respondent as per record has since 78 looked after the disputed property and paid all the dues, taxes, which are required to be paid by the Council of Dimahasa. Therefore, the court here decides that from 17 kathas, the respondent shall receive 4 kathas and the rest will be held by the petitioner, being the male descendant of Hengdong. So where is the written, Lord? That because of male descendant, he will get more and others will get not. So, my lord, there is nothing to prove. And my lord, which customary law? The Honorable Court does not refer to that. So and so the original landholder of disputed land, in Dimasa customary law, the sons.
Chaudhary, I'll tell you, we face a lot of issues when it comes to codification of the tribal laws. We have a law research institute.
Yes.
And I am associated with that.
My lord.
When we engage people to make what you call people who are from this region and know the
Customary
laws for the documentation, there is a lot of resistance from all the villagers not to record it.
Oh.
You will find very recently 15 books have been released on customary laws on various practices in the Northeast. Even last year, about 8 books were released. So quite a lot of work is being done for recording of
that research,
for researching the practices. There is strong resistance not to have it recorded.
Not to have codified rather.
Codified. There is a lot of resistance to record names of people who describe the practices. So therefore, it's not serving the interest of the people.
Yes.
And there is resistance also to record.
Hello, can you
So therefore, what we record in the book is that this is not a because this is not authentic, but this is what research shows us.
Hello, can you see the trend which will set from these cases? Any Tom, Dick and Harry can come and claim property on some ground. It's a very dangerous thing, my lord. At least, my lord, some minimum, my lord, semblance of rule of law has to be respected. I know customary practice will prevail. There is no dispute. As per the customary practice, my lord, then the first point is, my lord, non-joinder of necessary party.
Right.
Because Hemdong Mohan Haflongbar, he had 4 sons and 2 daughters. Now only 1 daughter and 1 son is involved. Others are not even made parties, my lord. And nobody has come to claim property over me, my lord, over all these years. Since 78, I'm in occupation of the land. That's why, even, my lord, there is a certificate of possession also apart from the patta. That is, my lord, page 36. What else I can occupy, my lord? Kindly see. Land possession certificate. This is to certify that land measuring 17 katha covered by so-and-so, Dag number so-and-so is in possession of Sumud Hozai of Haflong. I am having possession, I am having patta. Now, my lord, on the plea of, my lord, some customary law, my property is sought to be taken away.
That too, my lord, had it been a case where the plaintiff or the petitioner had established his right, indirectly, my lord, it's a declaration of right, title and interest over half of the property without following the due process of law. Even customary law has not been followed. Which customary law has been applied? And my lord, kindly see the burden either party could not discharge, therefore the learned court will not discharge the burden. So my humble, and my lord, most interestingly, a notice has been issued. Now the court below wants to execute also. And today is the date fixed, my lord. And I have been warned that if I am not present, then they will take legal measures against me. I do not know what legal measures.
Where is that?
No, that is not there, my lord, but that is what we have been told.
In this matter, I am appearing for the respondent demands of autonomous council. Since this is a matter involving the conflict between the petitioner and the private respondent. So without hearing the private respondent, if your lordship passes any interim order, then private respondent will be prejudiced because lordship the
Position
partner,
has to be protected.
lordship,
Position has to be protected.
Yes.
When
lordship, regarding the patta which my learned senior has referred, same patta that private respondent has also been allotted by the council. Lordship, I haven't got the
So
copy of,
then you see, it has been allotted by the council. Then why a litigation?
Yes,
lordship.
You will have to claim right for arising out of that patta.
yes.
Lordship, that is already been
But
claimed.
that part was not part of the record before the court below.
No. That patta has already been there, lordship. Lordship, we can't tell us, lordship, regarding the patta which,
So then why a civil, why a litigation for under customary law?
and
Yes.
moreover, lordship, as per demands of customary law, this is customary law practice, lordship. Lordship, may kindly peruse this, page 17, lordship. I am marked with lordship, page 17. My only prayer is, lordship, let at this stage notice may be issued and let the other side appear and,
No, if it is executed, then who takes the
Yes, what
responsibility?
will remain?
lordship,
Who takes the responsibility? Will the state takes responsibility
Not to execute the order.
after execution of the order?
no, it has not been executed because the order which was to be executed the day before yesterday only. And I have been informed from the council that the petitioner has not participated in that process. That is why the process has been followed.
That means process has been issued.
Yes.
Lordship, the process was started, but it
Now
was
please
being
tell
followed.
me, under which law, if a judgment letter does not appear, the court will not execute?
That is up to the
And,
discretion.
and where is the law that in an execution proceeding, the other side has to participate, otherwise there will be penal consequences?
No, that is not.
No,
so,
there.
Lordship. So at this case, Lordship, notice may be issued, Lordship.
No, notice will be issued. Definitely, we are not deciding it today.
Yes, Lordship.
But the only issue resides,
Ah.
the issue is whether it has to be granted. If you undertake that, well, on behalf of the council, that you will use the state machinery not to execute it, then.
Yes, we can, Lordship.
You can.
We can, not to execute.
My lord, though my learned friend has given that undertaking, but my lord, I think parties should maintain status quo as on today. Otherwise, my lord, it may have create some complications. And my lord, my learned friend is representing council only.
Yes, Lordship. I am.
But how come he is so keen to protect
no,
the
I-
private interest?
Whatever it is,
I am not protecting any private for this. Lordship.
Mr. Das, please tell me,
I'm sorry, madam.
no, Mr. Das,
Ah,
Lordship.
case, Mr. Chaudhary refers to a pata. Which page was that?
Yes, my lord,
Yes.
page 34.
How do you say that this pata does not infringe pata at page 34, this document which you have produced? How does it not infringe the pata at page 34? We'll tell you why we think so. Schedule is down below.
Yes, sir.
In page 34, the schedule is pata number 479.
Yes, sir.
In this, pata is 1, 2 to 3. Village is same, district is same, dark number is also same, 171.
Yes.
GHT old, sheet number 2, same. Now, area contained is 17, is page 34, here it is 13.
Yes. 13.
Boundary is jeepable road.
Oh, the first
South footpath. East is smooth hojai. Instead of that, it is jeepable road
Yes, Lordship.
and holding of Sri Mukul Dev, the plot of Mukul Dev, the same.
Lordship, this pata has been issued after the learned court below has passed the order.
Yes, first order.
In favor of both the parties. That is 70, out of the 17 kothas, 13 kothas will be in the possession of the private respondent and 4 kotha in
So
the.
it is out of this pata, it has been carved out.
And
Lordship.
now the appellate court
Yes.
order says half.
Now the appellate court order says half of.
So
That
this
is why,
pata has no meaning.
that is why I am saying before your Lordship that let at this stage notice may be issued, Lordship. Regarding the other one, I have already given assurance to your Lordship that no demarcation will be done, Lordship. Lordship may.
Well, how can my learned brief undertaking will have got a simple reason?
Maybe.
Courts are independent courts.
But tell me that
If Lordship peruse page 38,
no, you see, we have experience here on judicial side, this court, not me as a judge, but this court has experience of Chakla Tinga tea estate. Correct?
yes, Lordship.
How many people had died? You remember? There was 17,
Yes.
what you call, I just forgot, 15 or 16 people
Exact
died.
number I also don't remember, Miller,
There was-
but it was a
there was,
ghastly murder.
There was, what you call, death sentence to 3, life sentence to about 17,
Yes, Lordship.
correct? Now, you undertake that the state will not give any protection to execution. How do you take steps if the respondent takes steps for escape the land?
Yes.
Lordship,
What will you do to assure to the court that the respondent attempt to enter into the land would be protected or thwarted?
no, that has already been protected by the district council court that no one can enter into that fact.
Where is that?
The district council court has already passed
Where
that.
is, where is that?
It has not been annexed in this.
No. Where is the
It has already in the first initial date of hearing only, it has been passed.
Oh,
No one should enter
Mr.
nor
Das,
any
Mr.
development.
Das, this is something new to us, because we are living with a concept that the order of the trial court would merge with the order of the appellate court.
Yes.
If anything contrary is passed. So therefore, any order passed by the trial court, which is not continued in the appellate court, will lose its efficacy.
Yes, Lordship.
So the new decree which will prevail. Therefore, we are unable to accept your contention that you can take, you will have the authority to prevent the respondent from taking over the land without order of the court.
No, they will not, means council will not hand over the land to any of the parties, Lordship. Neither the council nor the council court will hand over, Lordship.
Is India that simple? Have you not seen any border disputes, boundary disputes, where people are murdered, killed?
Lordship, that is the, till
My-
date, Lordship, this dispute arises from the year 2022. Till date.
Give me
it's
the
going
name
on.
who will,
But
give me the
nothing-
name of the authority who will protect.
Lordship,
Give me the name of a person who will be the authority whom direction will be given to protect.
the Secretary Revenue, Lordship,
Secretary Revenue, okay,
and sales organized.
right. Mr. Kim Chaudhary, Lawyer, Senior Counsel, assisted by Mr. Raj, Senior Counsel, the petitioner. Also heard. For government, you are there, yes. Bernard Brandon, additional senior government advocate appearing for the state respondent numbers. One, and Mr. Aaron Das, and it's standing also for the
2, 3 and
Civil Autonomous Council representing respondent numbers 2, 3, and 4. Next one. By filing this application under Article 227 of the Constitution of India, the petitioner has a say order dated 11/11/2022, passed by the learned
Judge subordinate,
judge subordinate
district council.
from Bima Hasao Autonomous Council Board, Haflong. Just take it together, as well as the order dated 12/12/2022, passed by the Secretary, Revenue, and Civil Autonomous Council, whereby the allotment of land in favor of the mother of the petitioner, as well as the mutation order dated 6/12/2014 in favor of the petitioner were cancelled. And the land was again mutated in 2 parts in the name of the respondent number 5, namely, Srimati Shukla, SUKLA, Aflongbar, HAF, LONGPAR, and the petitioner.
Yes, yes.
Yes,
And the petitioner, namely, the Sumut, SUMUT, Ojai. What is the 6/5 order?
it's the order by the judge, district council court, appellate order,
Where is that?
page 134. Ah, whereby, my lord, it was made 50/50.
So challenge is also made to the order dated 6/5/2026, passed by the judge, NC
My lord, in appeal case number 258 of 25, on top right hand side.
by the judge, NC Hills Autonomous Council Court, Haflong, in appeal case number 258 of 2025. By setting aside the order passed by the subordinate judge court, This is 9/6/2022. Mr. Chaudhary, some confusion.
Yes, my lord.
This order, page 134,
Yes,
you please come to 136.
yes, my lord.
It refers
Huh.
to appeal case number, sorry, the judgment of the subordinate judge court is set aside.
Yes,
Now, in paragraph 1, page 134,
yes,
subordinate judge court proceeding,
yes.
order is dated 9/6/2022. 9/6/2022 is not under challenge here. What is that order, 9/6/2022?
Lord, it does not refer to any date, my lord. The appeal arises from judgment order passed by the subordinate court.
No, the land, that the land dispute, page 134,
Yes,
that the land dispute.
that
was
therefore
registered
High Court has, no, there was a proceeding before this court, my lord. High Court remanded the
by-
matter.
Remanded the matter.
Actually, my lord, initially that appellate court was not there. So against the order of the subordinate court, we approached this honorable court. During the pendency of the proceeding before this honorable court, the appellate court was constituted. Therefore, High Court referred the matter.
I'm finding it some difficulty.
My lord, by that order, matter was referred. Page number 40, my lord.
Page number 40.
Yes. Land dispute between Sukla Hafrongbar and so and so. With reference to there, I am directed to refer the land dispute of Sukla Hafrongbar so and so in original page number so and so
In
40.
this order, which order has been set aside is not mentioned. Page 134. to
Yes, it
136.
is not mentioned, but that is the order, my lord. Because that is how that patta and all were issued.
That means you are referring to.
Yes, on first, the substantive order is 11/11/2002 by the judge subordinate court and 6/5/26 is by the appellate court.
Please give me the page numbers.
My lord, 69 is the original order of the judge subordinate court.
Yes, that is marked.
And
134 is
and 134 is the appellate order
Yes.
of the judge district council
You are challenging 6/5/2026,
as well, yes.
11/11/2022.
Yes, these are the two substantive orders.
And what is this 30/12/2022?
30/12 was order pursuant to the judgment of 11/11/25, 22, my lord.
Which page is that?
Yes,
72.
72. In pursuance of the judgment and order passed by the subordinate Disma Hausa Autonomous Council, White order dated 11/11/22, land measuring 17 kasa, which was allotted to Srimati Urmila Hojai, White so and so, and transferred of land measuring 17 kata from Urmila Hojai to her son Sumud Haflong is hereby cancelled. Now that order has marked with the appellate order. So all these things have gone now.
Does the parties, I'm just. Are the parties politically very highly connected?
Looks like.
Because
Both the parties. Both the parties.
No, I can't be. Had I been so, I've got to come rushing to the honorable court.
It seems like that, Lord. Both the parties are highly politically connected.
Next order. The Learned Senior Counsel for the appellant has submitted that in the meantime, pursuant to the appellate order, this likelihood of an execution being proceeded with which would deprive the petitioner of his rightful land. Countering the same, the learned standing counsel for the NCL's Autonomous Council has submitted that pursuant to the orders passed by the subordinate judge, Dimahasa Autonomous Court, periodic pata in favor of respondent number 5 has already been issued in respect of 13 kathas of 13 kathas out of 17 kathas of land claimed by the petitioner. The copy of the periodic lease executed on 9/1/2023 in favor of the respondent number 5 has been produced, which is made a part of the record. Next one. You should notice including notice on the prayer for interim relief returnable on, give a date after returnable on so and so. Take the requisite extra copies of the application be provided to the learned standing counsel for the NCL's Autonomous Council. First of the petitioner shall take steps within 2 days for service of notice on respondent number 5 by speed post with AD. Next. Prayer for interim relief, the learned standing counsel for the NCL's Autonomous Council has submitted that he has instructions from the Revenue Secretary that in view of the challenge to the appellate order made by view of this application, the state machinery will not be put to use for executing the order or for implementing the implementation of the periodic lease issued in favor of the respondent number 5. In view of the said instructions, specific instructions that the impugned appellate order dated 6/5/2026 passed in appeal case number 258 of 2025 shall not be executed by the NCL's Autonomous Council Court or any authorities under the Revenue Secretary. The court is inclined to provide that the Revenue Secretary shall do the needful in terms of the undertaking given by the standing counsel. Next, as an abundant caution, both sides are the petitioner and the respondents are likely to maintain status quo as on the date of the order. Next, in case the petitioners are threatened of any action by the state, by the NCL's Autonomous Council, liberty is granted to the petitioner to make a prayer for out of turn mistake.
And my learned friend will communicate the order today itself.
Next one, when the learned standing counsel for the NCL's Autonomous Council is requested to transmit a downloaded copy of this order to the respondent number 3. the petition shall also produce a certified copy of the order before the respondent number 3 to bring the order to the notice of the said authority. Next, list on.
3rd of June.
But insofar as this is concerned, I'll tell you something, because we have dealt with these issues even in Divas, I will tell you. The page you had shown, is come to this. This, and this is there, but we don't find anything contained here. That this, the village elders or the customary leaders of the various tribes, they have accepted this. There is no declaration in this book.
Okay.
That's number one. And number two, please open the second flag you have put. Second flag. That deals with, in the left side page, deals with pata. Correct?
Yes, gotcha.
Now you see, once a pata is issued. Once a pata is issued by the district administration. Everything would be subject to adjudication. Correct? Now, once a pata is issued, please tell me how will a customary law apply when there are two pata in two, the names of two different persons? That will be a pure and simple land dispute. And it cannot be governed by the customary laws. We have made a statement, we have recorded that undertaking, but I think that will not be proper. Please be well advised. It will not be proper. This will be pure and simple issue regarding the land. I'm telling you because at times officers of the court get into trouble with their undertaking.
Yes.
Just I'm putting it to notice.
Deep level.
I took note.
Instead of third, can it be 8 million? Third has a matter in 8 million. Deep level.
Item 4.
Can it be for time being, my runners can do it, time being.
Item 5.
Please, Your Honor. Sir, Musa, the amount of senior counsel is on leg. Can it pass enough of time being?
Item 7.
Item 7.
Which page is the impugn order? Mr. Sehgal, which page is the impugn order?
My lord. My lord, the impugn order is, my lord,
Page?
is 79. Because this is a year of an agreement, memorandum of understanding. And I am the owner of full number of buildings. Starting the school and colleges from 1992. Due to some financial difficulties, a memorandum of understanding was executed with the, my lord, respondents. And but by taking that advantage of the memorandum, they have started, my lord, doing some illegal acts. And the result of school becomes very bad. And I was not allowed to enter to the, my lord, to my own, to the buildings and to my even own building where I am residing as the principal of the college. And that, but they have filed a, my lord, suit. And in this suit, I have filed a petition that for informing, stating that the divorce caused by the, my lord, these plaintiffs, and they have declared that they are the owner of all the 4 buildings, and owner of the institutions. Then, and file a petition, my lord, under order. I will read the order, my lord, the page 79. My lord, the Honored Counsel for the plaintiff and defendant number 1 and 2 have filed Hadira. Today, this case is fixed for necessary order. On the petition number 3105/25 and 2574/25. To 2574, we filed the petition. Petition number 3105/25 was filed with the plaintiff, praying to pronounce judgment on admission stating that the defendants have admitted the plaintiff's possession of a dispute property. Petition number 2574 of 25 has been filed by the petitioner Rajesh Karmakar, stating that he is the attorney of defendant number 2, praying to pass judgment on admission, targeting the injunction order and to declare that the plaintiff has no sustainable claim for protection under section 53 of the Transfer of Property Act, stating that the plaintiff has admitted in the plaint that the suit property belongs to the defendant. The memorandum of understanding dated 19/12/2018 and special of property are not registered. Memorandum of understanding was revoked, and the plaintiff cannot take shelter of the under section 53A of the Transfer of Property Act. The plaintiff has filed written objections against the said petition, stating that the petition is not maintainable. The petition is vague and beyond the pleadings in the written statement. The content of the plaint and the pleading of the parties are to be read in a whole to receive the petition. The defendants have admitted that the plaintiff's possession of dispute property. The plaintiff cannot be evicted without recourse of law. The plaintiff has prayed to reject the petition filed by the petitioner. I have already heard learned counsel for both the sides on the petition. Very the materials on record. It appears that the filed order dated 12/5/23 passing Mijagas number so, whereof the plaintiff for granting termination injunction, restraining defendants from interfering with the control and management of the street education petition was allowed. The street property is an educational institution, and at present it is controlled and managed by the plaintiff. Defendants have also filed a suit, title suit number 50/19, trying to declare that defendant number 1, that is the plaintiff of this suit, has no right to take possession of the street property based on memorandum of understanding dated 19/12/18. It also appears that the issues have been framed whether the plaintiff has acquired the legal right and authority in respect to street property by virtue of memorandum of understanding dated 19/12/18. Petitioner has stated that plaintiff has admitted in the plaint that the street property belongs to the defendant, but it appears that in the instance suit, plaintiff has paid to declare that the plaintiff has right to continue and control the management of her street property under the memorandum of understanding entered between the parties. On the other hand, defendant is claiming that memorandum of understanding entered between the parties is not valid. Therefore, it appears that to me that it will be proper to decide the issues framed in the instance suit after taking evidence of parties, and it will be not proper to dispose the instance suit by allowing the instant petition. Any petition number so and so are rejected. So, my lord, now the memorandum of understanding, my lord, which was, my lord, entered into, my lord, in 2019, my lord, it was never registered. There were some conditions, and all the conditions they have violated. That is why, my lord, we have filed the petition that the suit should be dismissed under order. The application, my lord, my application may be seen for a while. At page 69. Page 69.
Yes.
The application under order 12, rule 6, led with order 14, rule 2B of the code of CPC.
How have you made out a case for judgment on admission?
My lord,
How have you been able to make out a case for judgment on admission?
my lord, I have only my prayer before lordship that the notice may be issued to them, and my lord,
It's okay, we'll have to have subjective satisfaction.
my lord,
How have you made out a case for the decree on admission?
no, we have filed the petition, my lord, that this suit is not maintainable. Because there is a judgment of the appeals court. I have brought.
What is the provision of order 12 rule 6?
Yes, my lord.
What is that provision?
Yes, my lord.
12 rule 6 says what?
Yes, my lord. I have the page. Yeah. Lordship, can you see the page? Doesn't order CPC can. Order 12, my lord, rule 6 at page of the CPC, new amended
No,
CPC.
it's okay. Just tell us what is the provision for.
My lord, unregistered document cannot be enforcing to. Both are
Okay.
unregistered, and I have already revoked.
I'm just asking you, what is order 12 rule 6?
What
What do you get by this?
My lord, yes, the endorsements on documents indicated as in addition evidence. Where a document relied on as evidence by either party is considered by the court to be inadmissible in evidence, there shall be endorsed thereon the particulars.
You are not
mentioned in-
reading order 12 rule 6. You are reading some other provision.
Madam, I am reading the rule 12, rule 12, rule 6 of rule 12. Order 12 put to. That means just a minute. Six. Yes, my lord. Sorry, my lord. Judgment on admission, my lord. Where admissions of fact have been made either in the pleading or otherwise, whether orally or in writing, the court may at any stage of the suit, either on application of any party or its own motion, and without waiting for the determination of any other question between the parties, makes such order or gives such judgment as it may think fit, having regard to such admissions. My lord.
So in this, in the plaintiff is asking for nothing. He is not asking for title. How
Well,
is this
on
going to be
admission
dismissed on
stage-
admission?
That would be filed a petition, Manoj, to under this provision. On where the admission of fact have been made out. The fact has been made out that the memorandum of understanding was an unregistered document, and by that document I cannot transfer 50 crores of rupees property. I have my 4 buildings, and they appreciated the understanding. That is why my lord, they filed a suit not to allow me to enter to the premises. Not to, even I am not allowed to enter to my residential building, standing on the center of the plan. And that is why, my lord, the power of attorney was already cancelled by me. And then, my lord, to avoid all these things, they filed a suit. And the Lion Trial Court, my lord, did not discuss about the written statement that I have filed. And did not there is that this, my lord, that the unregistered document cannot be entered into, cannot be given effect to. Beyond 100 rupees, lordship is aware that beyond 100 rupees, any document must be registered for transferring the land. It was not done. So lordship, section 7 of the registration of make and receive for a while. It is compulsory. That is why the Honorable Appellate Court in 2 judgments have held that if the document is unregistered, either in memorandum of understanding or said, this is illegal, and that cannot be enforced into the law. Forcefully not doing all these things. And this petitioner is an old man, and they have taken the advantage. My relevant portion, my lord, and this is the first paragraph. Transfer property, being also for the power mode of transfer on bench of general power of attorney shells or shell agreement. General power of attorney will transfer while transferred alike as a GPA living will transfer legality. Hence, immovable property can be transferred conveyed only by deed of conveyance shall be duly stamped and registered as required by the law, explaining the nature and scope of the agreement for sale, power of attorney, and living will held. GPA shells or SA GPA living will transfers neither convey any title nor do any amount to transfer of or clear interest in a whole property, except to the limited extent. Section 53A, observations of the daily high court so and so. The power of the requirements method. Now, Lordship, the conclusion may be seen. You heard the Honorable Episcopal paragraph. Conclusion. Yes, my lord.
Okay,
Yes,
we have seen that.
conclusion may be seen, my lord.
We have seen that.
My conclusion, Lordship, may I read it? My lord.
Not required.
Yes. So any transaction, only the parties should not deprive the government from being registered as because stamp papers are required. So to earn the black money, some of the party did not register the agreement. So agreement is a must to be registered. And these have been raised
So,
in the
Saikya, we are
petition.
dismissing this petition.
My lord.
We are dismissing this petition.
Why, my lord? Notice may be issued by lordship.
No, we are dismissing it.
My lord, just a minute, my lord. Lordship, just a minute. My lord, I already failed to, my lord, place the case. Lordship may kindly see my paragraph 8 of my petition. My lord, paragraph 5.
25.
The petitioner has, defendants have also filed the statute number in one, via the counterclaim praying to declare to the plaintiff that the present respondent have no right to take possession of the said property on the basis of an unlisted memorandum of understanding. A copy of the unlisted memorandum of understanding is annexed as marked as annexed fee. That's it. Annexed fee may be kindly, forever, may be kindly
You are
be seen,
reading
my
page 25.
my lord.
You are reading page 25.
No, I'm reading page 5 of my petition. Page 5, my lord, paragraph 5. And I have annexed a copy of the unregistered memorandum of understanding at annexed 3, my lord.
We have read that.
Annexed 3, my lord.
We have read it.
So, my lord, and by way of an unregistered agreement, how they can compel me, how they can stop me, and my lord, the suit is not maintainably served. Or else, my lord, you lordship may kindly give me 2 days time. I will come prepared on this case. Lordship.
No. That can't be
No,
permitted.
if I cannot satisfy today, my lord,
That can't be permitted. We have heard it. We have spent time.
then my lord, kindly see, my lord. My lord, just a minute, my lord.
If you want to take time, you should have taken adjournment before you start.
No,
Not
my lord.
midway.
My lord, I'm sorry. So, you lordship, kindly see, my lord. Lordship, kindly see.
You've seen everything. Your petition as well as this revision is a misapplication in law.
My lord.
You are abusing the process of law.
Yes,
The MOU does not say that you are handing over the property on sale.
no, my lord,
That's not
memorandum
an
of
agreement for sale.
no,
It's
memorandum of understanding may be seen, my lord.
I have read it.
My lordship,
Your MOU says that you are handing over the property for the purpose of running the school.
yes.
So that is not a sale.
Lordship, let me read the memorandum, my lord. Just a minute.
You should have read it at your
No,
chamber,
my
not
lord,
here.
kindly allow me for 5 minutes time. Let me read the memorandum of understanding.
You have read it.
No, my lord, let me read, lordship. Annex 3. Page 57, lordship. I will read the,
So we have read it.
my lord, whereas the first party is the managing trustee of the land and irrigation trust.
You just show us where, from which line in this MOU, you are reading that there is a transfer of property.
My lord, that is my lord, last, let me give only 2, 3
You
minutes.
should have read it long back.
My
This
lord,
is not the
that-
place to read.
Let me read 2 minutes time, my lord. Hello. That in pursuance of the aforesaid negotiation and in consideration of a rupees of 1 crore it is invested by the second party against the discharge of liabilities. The first party has handed over the total management of the education institutions along with all existing
So management,
infrastructure,
not the
including
sale of
land,
property.
including land.
Yes, management, why not?
How
What
I
is wrong
can
in taking
transfer?
over?
Madam, how the land can be transferred without registration?
We'll deal with it.
Madam,
You
just-
obviously don't want an
and-
answer from this court,
and-
because we'll not suit you.
my lord, my lord,
If you insist,
Lordship
we'll
is
pass
my lord-
observation, this will not
Lordship
suit
is
you.
veteran in this civil line. Let me express my.
I am not a master, I am just a
just-
student.
Just a minute, my lord. Just a minute.
I'm
and-
just a student, that's why I asked you to read the property, the
and-
provision, I asked to read this documents, I'm not a master.
My lord, you lordship, we presume you lordship is the master of the subject.
No, definitely
Yes.
not.
We have seen.
I am only an authority in the chair to decide the matter.
We have seen during your lifetime while you were also lawyer.
No,
You
please,
were the,
you see,
you were the,
Mr.
you were the
Saikia,
expert one.
Mr. Saikia,
Lordship,
please come
just-
to the.
Just a minute,
come to
that
the
is all, lordship is, let me just, my lord.
There's no
in-
word in this
Including land
MOU.
and other immovable properties to and in favor of second party with all its existing facilities, including the right and operation, bank accounts, delivery of taking over the management and then that this therefore that this date of taking over possession of the said institution will be at liberty to run and manage the institution at the best and welfare of the student staff. The first party has agreed to not to cause any sort of inference into the running of the management. The first party have agreed to provide full and complete information regarding the affairs of the.
Please show me only one line where it is said to be the transfer of property. by this MOU.
Paragraph, lordship,
You see, we had this, next door, we had a Brahmaputra hotel here, which is
Madam,
a ITDC property,
my lord, that is what the paragraph.
Assam Tourism Development Corporation property.
My
That was
lord,
by way of an MOU.
no, it is lordship correct, but having delivered up and taking over of management and property, immovable property.
Definitely,
Paragraph one,
taking of the property for
property-
management does not mean sale of the property.
immovable property is transferred. Immovable property,
Mr. Saikia,
my lord.
we are not under any duty to tell you why we are passing an order. Don't take us to that interaction where we tell you why we are passing an order. We have told you that you have not made out a case and we are dismissing it.
No,
I'm not bound to tell you why I'm framing my mind, why to dismiss it. I have asked you, you have told me to read the MOU. We are reading it, and we have told you we have read it earlier also. And we are again telling you that show us any line which suggests that it is a transfer of property.
my lord, the memorandum, by the memorandum of understanding also, property is handed over.
Why not? Next door is the planetarium. If you have money, you can go and make an agreement with the government of India or the, what you call the Science and Technology Department of Government of Assam and take it by way of an MOU. They'll hand you over the property. What is wrong in that?
My lord, property to be handed over has to be registered, lordship, that is my submission. Property to be handed over either of MAO or sale has to be registered as the apex to the.
Then I'm sorry to say, you are not duly instructed in law to make that submission.
My lord,
Handing over of property is not sale within the meaning of section 54 of the Transfer of Property Act.
the immovable property, my lord, the apex to sale for making a memorandum of understanding, even it should be registered that I have pledged the judgment to your
We'll
lordship.
deal with it.
My lord, conclusion may be seen
Mr.
of the
R.
judgment.
Saikia, Learned Senior Counsel, assisted by Ms.
Conclusion
M.
may be seen.
Sharma and counsel for the petitioner. Next, by filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 6/8/2025, passed by the learned civil judge within bracket senior division bracket Kinsukia, thereby rejecting the prayer made in petition number 2574 of 2025 in connection with TS number 30 of 2019. Next paragraph. Petition number 2574 of 2025 is an application under Order 12 Rule 6 read with Order 14 Rule 2 within bracket small b of the CPC inter alia, praying for rejection of the plaint on the ground that the respondents, plaintiffs have made an equivocal admission that the defendants are true owners of the suit property. Next paragraph. The facts, in brief, is that the respondent number 1 is as plaintiff in TS number 30 of 2019 had filed a suit for declaration, perpetual injunction and other reliefs to the effect that seeking declaration that the plaintiff has acquired valid and enforceable right having legal authority in respect of the suit property under memorandum of understanding, declaration that the plaintiff is legally entitled to continue the control and management of the suit property, and the defendants have no sanction in law to cause any interference, for declaration that the plaintiff is legally entitled to manage and control the suit property on the basis of investment made in accordance with MOU, for declaration that the plaintiff, having acquired the actual position from management and control of the suit property, cannot be dispossessed or otherwise obstructed therefrom, save and except in due process of law, for declaration that the power of attorney executed by defendant number 2 in favor of the plaintiff in furtherance of MOU has continuing legal effect and force, and the plaintiff already giving effect to the same is legally entitled to act and continue under the same for declaration that the revocation of the cancellation of power of attorney dated 19/12/2018 by the defendant number 2 is illegal, inoperative, or null and void, and cannot have any effect upon the running and managing of the suit property by the plaintiff, and the said document is liable to be cancelled and as well as for other use. Next one. It would suffice to mention that by way of MOU dated 15/12/2018, the total management of educational institution under the name and style of learners apostrophe high school and learners apostrophe junior college with residential building standing on the plot of land which is more fully described in the narration of the MOU was handed over to the petitioner number 2 to the respondent defendant number 1. Purportedly on account of agreement between the parties by which the respondent number one dash plaintiff respondent one is plaintiff. Plaintiff had agreed to invest an agreed amount of rupees 1 crore in the manner as provided in the MOU. Next paragraph. The learned senior counsel for the petitioner projects that in the proceedings, the respondent number one dash plaintiff had admitted that the ownership of the properties vested in the petitioner number two. However, despite the petitioner number two being the owner of the property covered by the said MOU, has been prevented to enter into the said building and to manage the affairs of the school. The educational institution, not school. Next paragraph. Accordingly, on the ground that the property in question was not transferred and the MOU was not registered, which according to the learned senior counsel for the petitioners is required under section 17 within bracket 1 within bracket B and 17 within bracket 1 within bracket C, read with section 49 of the Registration Act, the respondent number one, that plaintiff, cannot be permitted to take recourse to protection under section 53 capital A of the Transfer of Property Act. It is submitted that without registration of the said MOU, the respondent number one, that plaintiff would not be entitled to any protection under section 53 capital A of the Transfer of Property Act from 1882. In support of the said contention, reliance is placed on the decision of the Supreme Court of India in the case of Suraj Lamp and Industries Private Limited versus State of Haryana and another, within bracket 2012, bracket close 1 SCC 656. Accordingly, accordingly, the learned senior counsel for the petitioners has submitted that in view of the candid admission by the respondent number one plaintiff that the ownership of the property belonged to the petitioner number two, the suit was liable to be rejected upon admission. Referring to the statements made in paragraph 5 of this application, it is submitted that the petitioners have filed title suit number 53 of 2019 by way of counterclaim, praying to declare that the respondent have no right to take possession of the suit property on the basis of an unregistered MOU dated 19/12/2018. You have a copy of that counterclaim? You say that was a counterclaim?
My lord,
You have not annexed that counterclaim here. Is it available with you?
Mr. Fawcett. One minute, one minute. One from the show. One can give me petition process, indeed. Don't give.
I'll just take a short break and come back. If you have a copy, please give it here.
My lord,
I'll take a break and come back.
one can give me process, indeed. My lord, it is not here. My lord, I will not interrupt. Right of 21 of the Supreme Court judgment, it is written that any power of attorney, my lord, giving interest to the property, my lord, subject decision is not valid. My lord, paragraph 21 of the judgment for a while may be seen, my lord.
Okay.
Paragraph 21 my lord,
Okay.
of the judgment. In the state of Rajasthan versus Basanti Nahata, a grant of power of attorney is essentially governed by chapter 10 of the Contract Act by reason of a deed of power of attorney, and agent is formally appointed to act for the principal in one transaction or a series of transactions, or to manage the affairs of the principal, generally conferring necessary authority upon another person. A deed of power of attorney is executed by the
Okay,
principal.
we have read that. We have read that.
My lord.
So the, next one, in support of the said submissions, the counterclaim filed by the petitioner is not on record. Stop. On a query of the court, the learned senior counsel for the petitioner also does not have copy of the counterclaim. So therefore, the nature of prayer made in the counterclaim is not known. Next one. Next one. From the copy of audit sheet which are annexed as annexure 5 to this application, while noticing that while petition number 2574 of 2025 was filed by one Rajesh Karmakar, purportedly as attorney of the petitioner number 2 dash defendant number 2, for passing judgment on admission, the respondent number 1 plaintiff had also filed petition number 3105 of 2025, praying for a judgment on admission on the ground that the defendants had admitted the possession of the plaintiffs over the plaintiff over the suit property. The next part of the learned trial court, having considered the petition, took into consideration that the defendants had filed starting suit number 50P of 2019, praying for declaration that the defendant number 1 within bracket, i.e. the respondent number 1 dash plaintiff in TS 30 of 2019, bracket closed, had no right to take possession of the suit property basing on MOU dated 19/12/2018. Full stop. From the copy of order sheet annexed as Annexure 5, it does not appear that both the proceedings of TS number 30 of 2019 and the proceedings of TS number 50 of 2019 are being taken up as the suit and a counterclaim. Therefore, it appears that both the suits are analogously being tried. Next one. Although the learned senior counsel for the petitioner has tried to project that by way of an MOU, if the management of the property is transferred to the respondent number 1 plaintiff in TS 30 of 2019, such an MOU is required to be compulsorily registered to stop. And in support, the case of Suraj Lamp and Industries Private Limited within bracket Supra was cited. Next para. The learned senior counsel for the petitioners have not been able to show any statement in the said MOU by virtue of which it can be culled out as if the property described in the said MOU was being irreversibly transferred. Full stop. On facts, the case, the present case in hand is not similar with the facts of the case present in the case of Suraj Lamp and Industries Private Limited within bracket Supra. Next para. The said judgment proceeds with the premise that there is a ongoing practice that properties are being transferred by way of power of attorney or by execution of an agreement for sale supported by power of attorney. The modus operandi of such agreement for sale and the general power of attorney is more fully described in paragraph 2 of the said judgment. Full stop. None of the the said clauses referred to in paragraph 2 of the said judgment is found to be applicable in the present case in hand. Full stop. Therefore, the learned senior counsel for the petitioner has not been able to satisfy that the MOU partakes the character of a sale within the meaning of Section 54 of the Transfer of Property Act. Full stop. The MOU appears only to be taking over the management of the school and the properties associated with the school. Full stop. This is further fortified from the prayer number D of the plaint in TS 30 of 2019, by which the respondent number 1 plaintiff is seeking a declaration that the plaintiff, having acquired the actual position, management and control of the suit property, cannot be dispossessed or otherwise obstructed therefrom, save except in due process of law. Thus, the respondent number 1 plaintiff does not seek a perpetual title over the suit property. Therefore, the ratio laid down in the case of Suraj Lamp and Industries Private Limited within bracket Supra would not help the petitioner for any reason whatsoever. Next paragraph. Accordingly, the impugned decision of the learned civil judge within bracket senior division bracket Sukia to hold that it would be appropriate to decide the issues framed in the suit, and after taking evidence of the parties, and it would not be proper to dispose of the suit by allowing the said two petitions, and accordingly petition number 3105 of 2025, the one filed by the Karmakar, attorney of so Karmakar, attorney of respondent number Rajesh Karmakar, attorney of defendant number 2, name be Varghese VRGACSE Panjikaran PANJIKARAN and petition number 2574 of 2025, petition filed by the petitioner as respondent number 1, both for rejection of plaint were rejected. Full stop. The court does not find the said decision to be contrary to any law for the timing in force. Full stop. The court does not find the said order to be perverse or illegal or based on extraneous materials. Full stop. Next, therefore, this revision fails and the same is dismissed. Next, nothing contained in this order shall prejudice the parties when the suit is heard on merit. Yes. Left over item 4.
Court.
Of the
Make his election.
Yes.
Well, we have come against the order by which my application under Order 7, Rule 11 has been rejected by the trial court below. So the facts are like this.
Where is your petition and where is the order?
Yes, ma'am. Malad, kindly have a look at.
And where is the plaint?
Malad,
Plaint, the order and that.
into an order, ma'am.
No, the plaint, your the petition and the order.
Malad, Malad, my application is at page 186.
186.
Yes.
And the order.
Under the impugn order, you'll also find at page 204.
Page number?
204, Malad.
Yes.
Well, the plaintiff was the director of the defendant number 1 company, the petitioner number 1 hearing. But he was not a shareholder. He did not have any single share of the company.
The respondent plaintiff.
Yes.
Okay.
And when the seal deed was executed, that your lordship find at page 59.
51.
59.
9.
Dated 6th of July 21 to 2011. At page 60, your lordship finds the name of the company. The company was at that point of time represented by the respondent as director.
Yes.
Based on that, my lord, the name of the company was mutated in the record of rights, represented by the director. Lordship knows, my lord, in Jamabandi, my lord, basically the name of the director also appears along with the company. My lord. Page 72 is the extract of the translated copy of the Jamabandi, my lord. That entry number 50, your lordship is Messrs. South Valley Insapol Private Limited, represented by its director, Sri Chandan Deka. Remark column is on the right side, my lord. Now, sometime on 15/9/2012, the gentleman resigned from the company. The resignation letter your lordship finds at page 92. 59, 2012,
But still, no case of order 7/11 has been made out.
but I'll demonstrate before your lordship, Lord.
You're using 630, he is not a shareholder.
No, Lord. What I am submitting before your lordship is, if your lordship sees page 92 is the resignation letter, and then your lordship would read with that form 32.
Where is that?
Page 45. This is part of the plaintiff documents, Lord.
So it's okay, he has resigned.
Yes,
Then you got the name of the shareholder is mutated in the, by correction in the.
yes,
job.
the name of the director, Lord.
New directors have come.
No, directors were existing. There were
Whatever,
three-
whatever be.
Yes,
but
yes, the name has been changed, Lord.
I don't read it so thoroughly.
My lord. Now, my lord, in 2020, see, he comes, my lord, and file this suit.
Yes.
Your lordship would kindly have a look at the prayer, my lord.
So you see, the cause of action can't be bifurcated. Page 32 is the prayer.
Yes, yes.
First is decree for resignation that can
Yes,
go to the company.
I'll come sequentially, my lord.
Then secondly, you will find that the meeting of board
Before
of directors
declaration,
that
my lord,
goes.
first issue, my lord, first prayer, my lord.
Decree for restoring the name of plaintiff as director. That goes there. Now, the decree for cancellation of order of the circle officer.
My lord.
This can't go to the company law board.
What the trial court has held, my lord, prayer number 2 and 3 is barred under 242H. If your lordship kindly look at that, my lord.
Where?
But what the finding by the trial court is that this part of the suit cannot be dismissed, though part is not maintainable, it has to go
There's
before
judgment of this
NCLT.
court as well as Supreme Court, which says the
Yes,
cause
yes.
of action for the rejection of plaint under or 11(1)D. cannot
But
be
I have
bifurcated.
no difficulty with the propositions, my lord. But my submission for your lordship's consideration is that that proposition do not fit in my case. My lord, recently Supreme Court has come up with a judgment, my lord, that your lordship also has to look into the clever drafting by which, my lord, it has been, my lord, that of course I am not carrying, but it's a 146-page judgment, but just I have downloaded, my lord.
That is the,
Yes, recently been, my lord, done one. I could lay my hand today morning only, my lord. I could not get a printout.
clever drafting is there in many cases.
Yes, yes. Lord, you,
Plenty of cases.
my case is very simple, Lord. Lord, a director who has represented the company in the sale deed can claim common right, title and interest as regard the property, Lord. That is the prayer that has been sought for if your lordship sees, and the trial court says that this is maintainable.
My opinion will not carry any weight. It has to be decided in the suit.
My lord, a registered sale deed which has been, executed in favor of a company. Lord, if a sale deed is executed in my name, Lord, can say that without challenging that sale deed, say that belongs to Mr. X. Lord, a company is a jurisdiction person. It has its own entity and identity. When the sale deed has been executed in favor of a company, can anyone or the director through whom the sale deed has been executed can claim common right, title and interest, Lord? The trial court says yes, this issue can be tried.
The problem is that under the laws, if you make a claim for
No,
land
Lord.
being declared as your
Lord,
property.
my commission for your lordship consideration is this. When Form 32 is a public document, where the resignation has been submitted, it's been submitted to the registrar of companies, my lords. He has not been functioning as a director. There is no averment. 12 years down the line. Lord, your lordship knows under the erstwhile act, if 3 meetings you don't attend, you cease to be a director. There is no pleading to that effect in the plaint. But only for resignation, Lord, the entire things can be stalled, my lord. So therefore, your lordship has to look into that clever drafting part, my lord. Lord, when the trial court says that resignation is a part which is to be
decided by the trial court, that letter also comes into play, my lord. And the form which has been submitted before the trial, before the registrar of companies. But how can this be bifurcated? What the end result would be, my lord, if a person would be director or not, my lord, it would be a decision of the director.
7.1D
My lord,
is, it should be barred by law.
my lord.
What will be the presumption for not
Lord,
challenging?
so
That
far
is
as,
not barred by law.
Lord, my submission, Lord, so far as limitation is concerned, it's a mixed question of law and fact. But in a given case, the apex court and your lordship has also held, if it is apparent from the record that it is grossly barred, then your lordship will dismiss that suit. My contention before lordship is this: when ROC form 32 has been filed, he has annexed, it's a public document, and the resignation letter is a part of that document. It's 12 years down the line. You cannot come and challenge that. You have been sleeping all through. And what, in an exception case, what kind of relief one can get by entangling me in this suit, my lord? Had it been a case 2 years, 3 years, 4 years, my lord, that would have been a different issue, my lord. My lordship also can take cognizance, but there is no averment, because when a claim should be filed, there should be a disclosure of facts also, that he has been attending that meeting. Could it be so, my lord, that once notice was not issued to him in 2012, he can very well continue not to be a director, and one fine day after 12 years has come and challenges it? Even, my lord, the incorporation of the name of the new director, even assuming the resignation letter is false, cannot be challenged, my lord. Because it's the prerogative of the company whom they want to be represented.
Where is the print? It is
Page 25.
25.
Yes. In fact, in point of information, if your lordship permit, my lord, in fact, these gentlemen, the defendant number 2 and 3 stood as guarantor for his loan in 2021. He paid his amount, then how the guarantee was released. So this is not part of the credits. I am not relying upon that. Only it's a point of information. Had there been any instances, my lord, he has always been in touch with us.
That would be of some information if some of your friends take a loan and the company agrees to satisfy the debt. So for that,
No, I'm also, my effort is to persuade your lordship, lord, that like it's a case where lord, that needs to be examined, lord, by your lordship. He could not have any cause of action, lord, claiming right title interest, common right title interest, when there is no challenge to the validity of the sale deed, which he has executed on behalf of the company.
what is that clever talking you were referring to?
I'm sorry, my lord.
Decision of which year?
2000, May 2026. Lordship Justice J.B. Padriya.
May 26.
Nowadays, technology also have some difficulty. The judgment which I am having in my mobile is being used for online hearing, not for hotspot connection. That's how I. Thanks, my right side. Thank you. Let me, my friend has assisted me a lot.
It should May.
Well, it has been reported in 2026 live law SC 478.
Name of the party?
Yes, party is Manjula and others, Mullah. Manjula and others versus D.A. Srinivas. A very long judgment, Mullah.
Majula versus D.A. Srinivas.
Yes, yes. The case is related to some Benami transactions now. SLP number, civil appeal number is 7370 of 26.
Got it.
Thank you. Otherwise, if the lordship permit me, I can take up, come tomorrow, and that's the my lord.
Start the way, and I pass it for the petition. Next one. By filing this revision under section 115 of the CPC, the petitioner who is the defendant number, who are the defendants
1, 2, 3.
in TS number 221 of 2024, have assailed the order dated 10/2/2026, passed by the learned civil judge within bracket senior division, bracket close number 1, Kamrup Metro, Gauhati, in Miss J case number 867/2024, in TS number 221 of 2024, thereby rejecting the application filed by the petitioner under order 7, rule 11 within bracket D, by holding it to be not maintainable. Next one. The learned counsel for the petitioner has submitted that the sale deed by virtue of which the property in question was purchased from the petitioner number 1 was the purchaser and represented by the respondent number 1. It is also submitted that the respondent number 1 had resigned as a director of the petitioner number 1 company on, where is that?
59, page 92, my lord.
On 15/9/2012, and to that effect, form number
32,
32,
page
where is
45.
that?
Page 45. my lord.
Form number 32 is filed before the registrar of companies. So it is submitted that this is a case of clever drafting by which the respondent number 1, in order to avoid to litigate before the NCLT, has made a prayer for restoration of his name in the land revenue records. In the plaint. Accordingly, it is submitted that if that as the case of the petitioners is that the respondent number 1 had resigned as director on 15/9/2012. The suit, along with all the prayers, would be barred by limitation. That's correct. You should notice returnable on so and so after 4 weeks. Petitioner shall take steps within petitioners shall take steps within 2 days for service of notice on the respondents by speed post with AD. Next, for the conflict with the petitioners that you ready to correct the postal receipt number and to submit the postal track report prior to the next date of next week. There is only one respondent. List on service.
But can we permit a dusty service also? More?
Petition to review the Maintain the process to the because of service, affidavit of service shall be considered for vesting.
You know, we have not sought any interim prayer.
It can't be.
Deeply like.
This another item, just I'll briefly take it up. Item 8. Input order ownership and we see my lord, page 38, my lord. They have produced the entire order sheet? No, my lord. It is my lord, in the order itself, my lord, that no date was fixed for my lord. There must be some order. After you file a plaint, in the defendants appear. Yes. There must be some order. Yes, I have an some order, my lord, page 29 on page 29. So 7-1 order clearly states for written statement. For the defendant, my lord. Yes. So defendant file on my lord, next page is 30, my lord. 23/12/2019, my lord. They filed an written instrument with my lord counter claim. Written instrument come counter claim, my lord. Where is which order you are reading? Page 30, my lord. Page 30, which order? There are two orders. Reading which order? 23/12/19, my lord. First one. The defendant number 126 submitted written instrument, financing copy there to the actually it is written instrument come counter claim, my lord. And then case fixed for my lord, settlement under section 89 of CPC. Thereafter, my lord, order dated 26/2/20 fixed for my lord ID, issue and my lord document. And that had admitted in the my lord input order also, sir. But you accept that condition for 5 years. That is there, my lord, but you did not, you received the copy of the council, council, then you don't make a prayer for written statement. You never ask for written- there is a council, some oversight by the council, my lord. By being a petitioner, my lord, he engaged the council, he overlooked the my lord. And for 5 years, you don't read it. This is now for evidence. No, evidence is over, my lord. Actually, case was fixed for judgment, my lord. One that. When did you realize? Now, again, case is fixed for argument, my lord. The alia just was transferred, my lord. So now, again, the case is fixed for argument, my lord. So, my lord, there may not be adducing any additional evidence or procedural of that. Only, my lord, WS, my lord. Very clear, plain.
Yes, then it says 11, my lord. And litigation income counterclaim is page 22.
And where is the written statement come counterclaim?
Page 22, my lord, page 22.
Continue to.
My lord.
But you see, it's very difficult to accept your proposition. The page 22 shows that for counterclaim, court fees was paid.
Yes,
The suit proceeded. And you can't file an evidence without reading the plain.
but in the order dated 23/12 to 19, my lord, page 30, it is, my lord, written as, my lord, this is recorded as written statement only, my lord.
You better proceed the, produce all the order sheets.
My lord,
Produce the entire order sheet
my lord.
of the trial court. You procure a certified copy of the order sheet and then ask them to send it to you through email and produce it.
My lord. Next date fixed on 22/5, my lord.
You can get it back tomorrow or day after tomorrow. Because in this form, we are not inclined.
And
Because
21,
you
my
have
lord.
accepted this for more than 5 years.
Yes,
The
ma'am. That is
position
there,
that written statement was there, counterclaim is there.
my lord, that is there.
And at all times, we can't blame the trial court. How it was presented, we don't know.
On 21st, then, my lord.
Hmm?
On 21st,
25th, okay.
21st.
As the entire order sheet of the trial court is not available on record, Mr. HR Amit and constitutional the petitioner. There is for some time. Next, in the event the certificate copies are obtained on a scanned copy thereof can be produced before the court. Next, list on 21. 21.
21/5.
No, 21, we only have matters. 22nd.
22nd is the date, next date, there, my lord.
21.
Right.
Yes.
Obliged, my lord.
It is Miller, one is Miller 9, and another is Miller,
Item 9.
and item number, item 9, item 17, and 54 Miller. I have to leave the court, Miller, today. Because date issue Miller today.
death ritual of my father-in-law, my lord. Today, he died, my lord, on 6 May, my lord. So I have to leave, my lord, so that may be free of next week, my lord, it is, or Monday or.
Okay, 9, 17 and
9, my lord, and 17 and 54. 17 and 54, same matter, my lord.
54 is on the prayer made by Mr. P. S. Dekar on counsel for the in item 9, he will be petitioner. In item 17, he will be appellant. And item number?
Item number 54, my lord. It is with connected, my lord, my lord, it is in that petition, it is with petition on it.
54, he will be applicant. The matter stands adjourned today as he is in bereavement. Next for list on.
Next, my lord, next week, my lord. Monday or
25, 5, and 26.
Time being item 4. Sorry, time being item 5.
I'm sorry, my lord, I was in division bench, my lord, that matter was going on, my lord. My lord, this revision petition, my lord, I'll just give the background of the case, my lord. I am a decree holder, my lord. I'm a decree holder to sue to us for, my lord, specific performance of contract, my lord. And ultimately, or by virtue of court order, by the contract, that the agreement was, my lord, signed by the court, my lord, while giving my position, my lord, that civil Nazir given a statement that there is some stranger in that particular plot of land. Then, my lord, those stranger, my lord, they file an application before the executing court under order 21 rule 97, my lord. And actually, that was barred by limitation, and I give my objection. And also prior to issue film as a preliminary ground, my lord. But that was rejected, and against that I come before this honorable court, and their division is pending before this honorable court. That is another issue, my lord. But the same stranger, my lord, now file a suit, my lord, separate suit, my lord. In that suit, after receiving the notice, I appeared, I filed WS. And after filing WS, my lord, I also filed a counterclaim also. In my counterclaim, my lord, no objection has been filed by the plaintiff, my lord. No objection filed, but only 90 days over. Thereafter, they file an application for, my lord, application to cancel my counterclaim. That, my lord, accordingly, my lord, learned court below, my lord, allowed their petition, and my lord, my counterclaim has been rejected. So against that, I came before this honorable court, my lord. Now, your lordship kindly see the ground of rejection, my lord. Because there is a separate procedure. They have filed an application for cancellation of my counterclaim under what? Under rule, my lord, 21 under order 21 rule 97. For filing for dismissing counterclaim is, my lord, plain. For dismissal of the plain, my lord, rejection of the plain, that is not the proper section, my lord. I even, my lord, your lordship kindly see the reasoning.
Where is your decree?
My lord,
Decree person.
decree, my lord. Your lordship will find my decree. Annexure 9, my lord. Page 78. This is, page 70, it is judgment, my lord, and decree, they are followed by the judgment. Page 86, my lord.
The second suit was by the third party.
My lord. That third party also file my lord, and order 21 rule 97 petition before the my lord executing court, my lord. Simultaneously, my lord, thereafter they have filed this separate suit, my lord. Separate suit, my lord.
What is the status of that suit, order 21 to 97?
My lord.
Order 21 to 97 application, what is the stage?
That, my lord, actually that was brought by limitation, and I proposed to I filed a objection, my lord, and my objection was rejected. Against that, my lord, there is a division pending before this honorable court, my lord. And there is a stay order operating, my lord. But now, the present suit, my lord, I am against my cancellation of my contract.
Okay, Mr. Motor will say about Mr. Kansai Bhagavad of copy today. Agreed by the order dated 21/3/2026, passed by the learned civil judge within the Junior Division, close number 1, Nagaon. In Tuesday case number 11 of 2026, in TS 56 of 2025, by which, by applying the provision of order 21, rule 101, and 97, rule 97. Rule 101 and 97 of order 21, read with section 151 CPC. And the counterclaim was rejected. The next account for the petitioner submitted that is of this being TS number 73 of 2016. By the petitioner for specific promotional contract, and this the decree passed in the said suit. Decreasing TS 73 of 16.
My lord.
Comma. The respondent numbers 1 to 11. Objectors are 1 to 11.
My lord, 1 to 11, my lord.
1 to 11. Appeared and filed objection as to execution. On the ground of they being in possession which was filed under order 21 to 97 CPC. Submitted that in the connection with the
My lord, earlier title should 99 of 19, man.
99 of 19.
19, man. Where I got the decree.
99 of 19. And what is this other suit? 53 of 16, that is, what is that?
53.
Of 16, what is that? '73 of 16, will you find it at page 24?
Page 34.
There's a reference to TS 73 of 16, and then again there's a reference to the land grabbing proceeding.
Is 34.
Page 24,
My lord, I just sit there, my lord.
paragraph 7.
That is another suit, my lord. That is not related, my lord. Probably the same party, my lord.
You're not concerned with that.
My lord. We are concerned with the 99, my lord. I got the decree, my lord.
19 of,
99 of 2019.
where is that?
Page 78, my lord. That is my decree, my lord. Bina Gunusa. That is suit number 99 of 2019.
2019. Because it read on 28/7/2023. Yeah? You filed this revision in connection with which matter?
My lord,
You said that the revision is pending in what connection?
revision in connection, my lord, while I am executing a execution proceeding was going on, in that execution proceeding, just my lord, this my lord, defendant number 1 to 11, my lord, they filed an application for a order 21 rule 97. But that was barred by limitation. That's why I made an objection. Our objection was rejected, and then I came before the Supreme Court. That I have managed.
On filing of this said application on the order 21 to 97 and 101. The petitioner had submitted an objection on the ground that it is barred by limitation. Was rejected, against which the petitioner opposed this court by filing
By way of revision, now.
revision application being
CRP 421 of 25.
CRP
421 of 2025.
125. Next. This is returnable on you take after 4 weeks. Returnable also and so. Petitioners shall take steps within 2 days by service of notice on the respondents by speed post PDD. The interim measure and give the next recovery date for the further proceedings of statute number 56 of 2025.
Well,
Pending before the court of learned civil judge, the record duly division, but number 1 from now on shall remain straight.
stay put in 3 days, my friend. Stay put in a week, I'll take
2 days.
2 days. Give me 2 days.
3rd of June.
Fine.
For motion, item 10.
The impugned order is at page 46, annexure 6, your lordship.
56.
By way of this order, your lordship, my PW1 and PW2 were expunged because they did not appear for cross-examination. PW3 was
Suit of Provision 1.
lordship.
Why evidence started in 26?
Lordship, the suit was stayed till 2018, your lordship. If your lordship comes to annexure 2H, page 28, your lordship.
Then you amended the claim.
Lordship. Lordship,
The case
initially
is
there
ready
were
for evidence from which date?
Lordship, actually, there were 2 suits, both for specific performance of contract against the same defendant. And our suit was subsequent in point of time. As such, it was stayed, your lordship. The prior suit was proceeding. Thereafter, the prior suit was decreed, and in appeal, it was remanded back with a direction to try both the suits together. Thereafter, there was an
MFA, your lordship, which was decided by this honorable court and said that this honorable court observed that both the suit has to be tried together. In 2018, it was disposed of, and then after 2018, the trial commenced. Then there was amendment of plaint. The party, the plaintiff of our suit passed away. He was substituted in 2019. And after amendment, the additional WS was filed. And from 22 onwards, the suit further issues were framed and it. But the case was ready for from where? Lordship, as per the order, your lordship, at annexure 6, page 46, it is stated that it is at the stage of evidence since 3/1/2023. And lordship, I admit, lordship, there were delays. However, there was talk of compromise also going on. That I have annexed the orders, downloaded copies of the orders. On 3 occasions, your lordship, it was sent to mediations, and then subsequently the mediation failed. The last, at page 44, (27/10/2025), it was the report of the mediator that the mediation failed, your lordship. And it was fixed on 10/12/2025. Annexure 5 is my petition for adjournment, your lordship, and the ground assigned, your lordship, is that the advocate was ill and he could not communicate with the parties. So the advocate's illness was cited and there was no negligence on the part of the parties because they could not be communicated by the advocate. That was the ground of the adjournment petition, your lordship. So these 2 PWs, primary PWs, PW 1 and 2, if these 2 are expunged, your lordship, they will be non-suited. PW 3 has been cross-examined, who is a stranger, not the party. Where is your evidence on affidavit? Lordship, that is not annexed here with your lordship. You have a copy of that? Lordship, that is not annexed. So you see, come to page 45. Lordship. After the prayer made in page 45. Lordship. You have stated here that due to ill health condition of the advocate, plaintiff could not be coming in time for which no evidence could be adduced. That means you have not filed an affidavit. It was filed, your lordship, to my to the instructions. Because PW 3 has already been cross-examined on the evidence, your lordship. That's the reason we are asking you. You see, now come to page 46. Yes. Now it can be seen that the case is pending at the stage of evidence in chief of PW since 3/1/2023. So it is fixed of the PW in chief. You can't allow this application. In that case, I may be given some time to take instruction as to whether PW was filed or not. Your evidence should also be hit by order 18-3A. So if PW was filed, your lordship already, it would not be PW 1. I'll just take the instruction as to whether PW's evidence in chief was filed already.
If required, because the lower court, it is fixed in the month of June, your lordship. The next date is 17th of June. So within 1 week, lordship, if required, I can apprise your lordship of that.
Here's from petition dated 21/6/2026. Here is here was regarding failure to produce evidence. As per the order dated 21/1/2026. For the case was fixed for evidence in chief PW since 3/1/2023. Accordingly, the impression is gathered that the evidence on affidavit of PW 1 and 2 was verified. Accordingly, so BJ Mukherjee and counsel for the petitioners pays for some time to obtain instructions. Matter stands at John Craig, this on when
Lordship, after a week, your lordship.
a week has been.
Much of it.
Supplementary item 48 for motion.
Yes, Mr. Bhullar.
Lordship. So both the courts pass the judgment against the petitioner, lordship dependent who are the tenant. On the ground of default.
Yes.
Lordship. So plaintiff filed a suit, lordship, claiming that the dependent is a defaulter since the month of, initially his claim is that since the month of August 2008, the dependent has not been paying the rent. So he is a defaulter, number one. And another plea has been taken that the premises is bona fide required. There are other tenanted premises also, as against them, the other tenants were also evicted. So far the defaulter part is concerned, your lordship. Along with that, along with the plaintiff filed a document admitting that he received the rent from the August 2008, which we have annexed with
He
our
amended the plaint.
lordship.
So he amended the plaint.
He amended the plan. So immediately he came to September 2008 and that is amended. So our claim is that, so far the tenant claim is that he, up to the month of July 2008, he issued the rent receipt, but therefore I did not receive the rent receipt, but he collected the rent up to month of October 2010.
Yes.
And when he refused to accept the rent for the month of November 2010, then he used to deposit the rent in court. Then come to know that the suit has been filed. Suit has been filed against him. So this is the position before the trial court. Evidence was laid. and the defendant asked the plaintiff to produce the rent receipts because his claim is that since 2000, September 2008, as the no rent has been paid, so accordingly rent receipt was not issued. So accordingly rent receipt was collected. So
Where's the order of the trial court?
it's like, I'll put right now annex or not it. This is copy. So operative portion lordship at trial court judgment paragraph number 22.
Just a moment. But to this effect, there is no order to the contrary. There's no, nothing on record to the contrary.
Okay.
This page 60 onwards.
Lordship. Appellate court judgment over.
Yes, para 17, 17, 18 onwards,
Lordship.
the, of this entire facts, there is no evidence to the contrary.
Lordship, rent receipt with the, so far the rent book is concerned, your lordship, that was with the plaintiff. So that is why we want to produce it, to call the documents that was not exhibited. So rather, this trial court as well as the appellate court, your lordship, in paragraph number 18 at page 61, lordship, paragraph number 61.
Page 61, yes.
Page 61 and also in the middle page, the DW1, your lordship.
Yes, DW1 during his cross-examination.
DW1,
During his cross-examination also admitted that he was depositing rents in July 2008 to November 2010.
in fact, our pleading, your lordship, we have not deposited the rent since the month of 2008. Our case is that we are depositing rent since the month of November 2010. But court observed, that's why evidence is to be looked into, your lordship. So court says that during the exam,
This is not available.
lordship,
Those things are not available.
lordship.
That's why you think there is nothing on record.
And
to the
another aspect, your lordship, there is an advance amount with him. He admitted,
No, advance, we have judgments of this court also.
lordship.
That advance unless you have agreement that it will be adjusted against rent.
Lordship.
That will be only on the expiry of the tenancy that you will get it refunded.
Lordship.
Unless you show that there is an agreement that every month there will be deduction from advance.
Yes.
That can't be good grounds for taking.
When the amount with him, that can be adjusted, lordship.
No. There is no theory of adjustment unless there is an agreement to that effect.
Unless and until it has been stated in the agreement.
That's what I understand,
Lordship.
subject to correction.
Lordship, that's the fact. So far, our High Court is concerned. So there's so many Vietnam decisions that if the money is with the landlord, so that is to be adjusted.
No.
And so far, your lordship, we
It does not contradict
exhibited
that.
the document, so far, along with us, which has the rent receipt. Oh, sorry,
No,
salon.
You take two plea. Number one, you take a plea that I have deposited rent. Number two, you say that he has got advance. Three, the court comes to a finding that as per the agreement, there was to be rent enhancement after every
Yes, yes,
that
that,
every year.
that.
Now,
5% is to be enhanced. Lordship. That was not enhanced. As per the, if the agreement is delayed, then 5% is to be enhanced.
we are defaulted then also.
So, to that effect, the lordship, correct? If the agreement can be realized, that the every 5 year, every 1 year, that 5% is to be enhanced. To that effect, it is correct. But so far the observation made in the, by the appellate court, lordship, in paragraph number, at page 61, lordship, the DW1 has executed,
We have made a shortcut
lordship.
because 2 days back I have forgotten. So I just refreshed my memory from page 61 to 62.
Lordship,
This, this 18.
lordship,
In this record, there is nothing to the contrary, which can make us take another view. Para 17 and 18, whatever the findings are, in this revision petition, there is nothing to contrary. To take a different view. You say that there is an evidence, but evidence is not here, available here.
yes,
So we are not admitting the case just to call for the evidence.
lordship.
If you produce, we can look into it, but we are not,
We can produce it, lordship, if I have to go through it.
because I am not admitting the revision.
Lordship, then maybe I'll give a answer, I can produce the evidence of the case.
How much time?
1 week, time.
Is a date when you want to go out. Query of the court, आपके भैया दंडित सीनियर काउंसिल suspect by Mr.
A single.
S.A. Singh. Submit that he produce the evidence and prosecution witnesses. So accordingly, magistrate is drawn today, list on. Then, If you give us liberty of any day, then Saturday.
Except.
Then give us a date. This Saturday is the best day. Acha. Just give us call from strategic office next. Just to return to it.
After 1 week,
Oh, no, I think it's not. You take back this, you produce on the next day.
Lordship.
When? At least on, so it's 1920.
আজি কিমান তাৰিখ?
18.
18 পিছত এসপ্তাহ পিছত after 1 week lordship, any day.
You go at a date after a week. 6th of May. 26th of May. 29. 29.
27.
29.
Oh, 28. 29.
This is item 13. Yes.
May it please the law. Now, my lord, in this case, my lord, the issue before the learned lower appellate court, your lordship, was as to whether the suit filed by the, my lord, the respondent's plaintiff is maintainable or not, my lord. Now, where in a case, my lord, a question is arising.
You are the plaintiff for the defendant?
Maintainable, my lord.
You are the plaintiff for the defendant?
My lord, we are the defendant.
Defendant.
We are the defendants in the court below. Now, here in this case, my lord, the suit filed by the plaintiff respondents, my lord, it was dismissed by the learned court below, holding that, my lord, the suit filed by the plaintiff respondents is not maintainable, as the other co-sharers of the suit properties were not implicated as necessary parties in the suit, your lord. That was the finding. Against that finding, my lord, an appeal was filed by the plaintiff respondents. So, my lord, again, my lord, that question has arisen, my lord, that whether the suit of the plaintiff is maintainable for not including the other co-sharers of the suit land in a suit for partition of the suit land, your lordship. Now, the learned court below, your lordship, instead of deciding this maintainability as the suit, my lord, at first in accordance with the law, my lord, has passed the impugned order, your lordship will find at page 123, your lordship, stating that the appellate court has the power to allow the parties to adduce additional evidence in the case, your lordship, and ignore the main issue, my lord. Now, nobody is disputing, my lord, that the appellate court did not have the power to allow the parties to adduce additional evidence. Thing doesn't lie here, my lord. Now, in a suit, my lord, where the suit itself is not maintainable, then what is the purpose, my lord, for adducing additional evidence? So, this is the case, your lordship, and accordingly, my lord, this petition has been filed against the impugned order passed by the learned court below. Your lordship will find at page 123.
Where is the plaintiff and the player?
Now, my lord, your lordship will see, my lord, plaintiff also peculiar, your lordship will find annexure 1, my lord. Now, what is the prayer your lordship will find?
Page 57, we are there.
Page 57, your lordship.
Yes.
Page 57, your lordship will see the, my lord, prayer made for a decree for declaration of joint titles of the plaintiff.
Just a moment, Mr.
Suit land is measuring 30 bigger than all, your lord.
Just
Page 57,
Mr. Dhar,
my lord.
you see, if somebody has been left out in this plane, would be only by mere either absence of the names in the Jamabandi which they are holding or inadvertence. You see, here they have made as many as 296 people as respondents. It is not a case of deliberate leaving out someone.
My lord, let me go, my lord. So far as the fact is concerned, your lordship will find this is a peculiar suit, my lord. I have not found any such suit in my lifetime, my lord. So that's why, my lord, for declaration of joint title of plaintiffs over the land measuring 32 vigas and odd, my lord. Schedule 1 below, that land is described by maintaining possession of the plaintiff over the land so and so. And for a preliminary decree for allotment of a separate share of the land measuring 32 vigas and odd. Total land is 32 vigas. Then these 32 vigas is to be allotted as the separate shares of the plaintiffs in the suit land. So plaintiff claims the entire suit land. That is the suit file, my lord. Now that suit was once decreed by the learned trial court also, my lord. And accordingly, we had to come before this honorable court by filing the second appeal. Now, page 80, your lordship will see, after remand, the trial court has passed this order. Page 80.
Seen that.
Have your lordship got
Judgment of the
page
first
80,
trial
80
court. 80, yes, we are there.
This is the
Judgment
suit
dated-
for declaration of title and partition by issuing a preliminary decree.
Yes.
Aftermath of trial, the suit was decreed in favor of the plaintiff. Having been agreed, the defendants prefer an appeal before the Honorable Gauhati High Court, that is RFA number so and so, in which an issue was framed, whether the plaintiff suit is maintainable in its present form, your lord. And suit was remanded back to this honorable court to decide all the issues afresh by giving adequate opportunity of being heard to both the parties. Now, your honor may skip and come to paragraph 6, my lord. How this particular issue was decided, your lordship will find at page 87, paragraph 6, your lord. After careful scrutiny, my lord, have your lordship got it? After careful scrutiny and analysis of entire evidence on record, it has come to surface that the plaintiff's claims over the suit land measuring 32 vigas and odd, plaintiffs paid for a preliminary decree for partition of the suit land mentioned in the schedule of the plain and for allotment of the aforesaid land measuring 32 vigas and odd as their separate shares of the suit land. It is settled proposition of law in respect of the suit for partition that every shareholder are the necessary parties to the suit. In the present suit, Abdul Rashid, Abdul Bari Borbuya, who were the brothers and concerned with 20 vigas, 7 kathas and so land, further co-sharer of the suit land, namely Saibur Rahman Borbuya, son of so, Sufia Begum, daughter of so, are not made parties to the suit. As they are co-sharers and having interest upon the suit land, they are undoubtedly the necessary parties in the suit. That is the first finding. Then, my lord, court has also, my lord, cited here a decision from the apex court, my lord. Now, your lordship will see, my lord, it is true that under Order 1, Rule 9 of CCC, no suit shall be defeated by reason of non-joinder and misjoinder of the parties. But there can be no doubt that if the parties who are joined are not only proper but also necessary parties to it, the infirmity in the suit is bound to be fatal, your lordship. That is the decisions of the apex court, my lord. In that light, I am of the opinion that the co-sharers of the Azmali land are the necessary parties. In their absence, proper adjudication of the matter in dispute in respect of the partition suit cannot be done, and thereby no effective order can be passed. Thus, on that count alone, the plaintiff's suit is bad for non-joinder of necessary parties and made fatal to the plaintiff's suit. Now, these are the, my lord, findings of the apex court also. Further, a plaintiff earlier prayed for preliminary decree under Order 20, Rule 18, CPC, but the plaintiff did not specify the allocation quantums of shares of each legal shares, my lord, shareholders. Now there is a Supreme Court judgment, court has cited. Now your lordship may skip 2 or 3 lines below. In the instant case, it is evident that some of the co-sharers who are the necessary and proper parties to the suit are neither made parties nor shown their quantum of share of land in the suit ducts and pattas, merely showing their share in fraction. In the evidence and so the additional evidence, my lord, additional evidence they sought to, my lord, adduce only fractional shares of some of the, my lord, defendants. They like to show, and behind, my lord, other co-sharers of the land who are not made parties, your lordship. That the court finding, your lordship may kindly see, who are necessary and proper pursuit, neither made parties nor shown their quantum share land in the suit ducts and pattas, merely showing their share in fraction. That is, Hydermia got so and so. Plaintiff themselves are dividing the suit land, your lordship. Hydermia got 1/7 share in city patta number so and so.
Tell you,
1/5 share in
page
so and so.
72. Mr. Dhar, please come to page 72.
Hmm?
Page 72.
Page 72, your lordship.
It starts from page 68.
Photo? 72, your lordship.
Page 68 first. In 68, there's a mention, 68.
68, your lordship.
68 and then 72. In 68, the share of Abdul Rashid and Abdul Bari is mentioned. 1 bigha, 1 kata, 2 chatak. They get by inheritance. Then come to page 72. In 72, there is a statement that Abdul Bari and Abdul Rashid got a separate patta rated in respect of 47 bigha so and so. So if that be so, which includes 1 kata, 1 bigha, how are the necessary parties in this suit?
The necessary parties, my lord, page 72 itself, your lordship will see. One name is there, Raskishore Chakravarti. He is also a, my lord, co-sharer of the suit land. Then, my lord, other people said they are not the parties.
No,
And it is the findings of the, my lord, it is the findings of the trial court that the suit is not maintainable because of non-gender of parties. Now,
That's why
lower
you see-
appellate court or learned appellate court below is to say something on that, either this way or that way.
No, we are examining it. That's why we are hearing you.
It is the
Abdul
duty
Rashid,
of
Abdul
the,
Bari-
it is the duty of the learned appellate court below to say something to show that these findings of the learned trial court is wrong. Court is not doing that, my lord.
And how do you
Court
get
is
this?
directing the parties to adduce additional evidence. Now, we have filed our objection, your lord. We said that what they like to adduce as additional evidence, my lord, these are already there in the case record. They adduce all
No,
these
we
sorts
understand,
of
but the
evidence.
genesis will only be the written statement.
Then
in
we
written
have, in
statement,
our
we get
objection
only-
petition, we have also stated.
No, you see, in the written statement, you refer to only Abdul Rashid and Abdul Bari.
Yes.
Where is the statement in your written statement
Abdul
regarding
Rashid, Abdul-
Saibur Rahman Borbuya and Sophia Begum?
No,
Saibur Rahman.
that is, my lord, that is the story, your lordship. That is the story of a
No,
particular
but where is that?
party.
We'll have to
Real
examine it.
state of affairs, my lord, page, my lord, 17. It is the case of the plaintiff. Plaintiff suit has real statement. That is the written statement, my lord. Written
You take the
statement
difference in
and
written
real
statement
state of
only.
affairs is under. That is a case of a particular party, my lord. That is the defendant.
We understand. But
Now,
how will the
out
court
of
find-
the pleadings of the plaintiffs and defendants, some issues were free.
So that's why you see, Mr. Dhar, we are trying to understand how this issue of non-gender came. It was in your written statement only,
Huh.
correct?
Yes.
And in your written statement, you make a statement that these two people had got a separate patta. Now that remains, that leaves aside only two people, Saibur Rahman Borbuya and Sophia Begum. Against them, I don't find anything. I may have missed it. I don't read so thoroughly. Regarding this two, we did not find anything. How
Now,
does
my
the
lord,
issue arise?
in their application, your lordship will find what they like to adduce now, my lord. After these pleadings, they like to bring some additional things, and that is there, my lord, in their present application, your lordship, which they had filed, your lordship
Where
will
page?
find. My lord, at page
99, relevant page 110, para 6.
which case, my lord, if you read. Internal, Again.
He gives the trial
This
court
is the
order.
application,
First
page
appeal.
99, your lordship.
Hmm?
Page 99, your lordship.
110, para 6.
Para 6. That the statements made in paragraph 1 of the application filed by the appellants to adduce additional evidence are matters of record. Appellants filed title should not be praying for a decree for partition of the suit line measuring so and so.
110, para 6.
100. 6. Is there application? 6, my lord, my learned friend, my lord, that the applicant begs to state that notwithstanding due diligence, such evidence could not be produced by the applicants at the trial court, and it is now by arithmetical calculation they have been able to crystallize the shares of contesting defendants. It is stated that the additional evidence only to clarify the evidence already on record, and is necessity for the appellate court to pronounce the judgment determining the property dispute in between the parties. So, my lord, firstly, my lord, my submission is that, my lord, very much simple. The firstly, learned, my lord, appellate court below is to decide, my lord, as to whether this way or that way, as to whether the suit filed by the plaintiff respondent is maintainable. And thereafter, all this question will come, my lord. So this is an inherent lacuna of defects of apparent or necessary, and it is necessary for the appellate court to have on record. Now, this lacuna, my lord, cannot be rectified later on, and they themselves are saying that these are the lacuna. Now, your lordship may, my lord, go, my lord, further down, your lordship. The appellant begs to state, and here, my lord, they had divided the length. Now, how much? Defendants number 2 and 3, defendants 4 to 7, 4 to 7, 8, 9, 4 to 7, defendants 1 to 9, then, my lord, defendants 10, defendants 11 and 12, 13, 14, 15, 16, 17, 18, and this way up to 8, 28, 33, then defendants 34, 187, 89, have no title or possession in arrest patta number so and so. So in this way, your lordship will find that, my lord, shares of some of the defendants, they like to, my lord, say that they have either have their shares or they do not have their shares, not whole of the defendants. And after all, who are they, my lord? It is to be decided by the court. There to exhibit their, my lord, either the land record or their title deed to, my lord, assist the court to come to a finding who is what, who is having, my lord, how much of shares in a partition suit, your lordship. And then court is to pass the decree following, my lord, order 20 rule 18, ascertaining shares of each of the parties in the suit. Now, so many persons who are not made parties. How the shares of these persons who are not made parties are to be ascertained by the court under order 20 rule 18 of the Code of Civil Procedure. That is the problem, your lord. And, my lord, while the trial court has passed the order, your lordship will see, my lord, there is a rider in that particular judgment in favor of the, my lord, respondent plaintiff. Your lordship will find they did not avail that, my lord, opportunities also, your lordship will find.
Mr. Dhar, you see, in a partition suit, there will be a preliminary decree. And pursuant to preliminary decree, there will be an inquiry.
Yes, yes, very
And
much.
in inquiry, if somebody comes,
No.
even though not specifically ordered, a person found to be in possession and having title will have to be considered. So how are you prejudiced?
Appeal lies, my lord, partition to appeal lies against the preliminary decree only.
Yes.
Now, High Court said that you, in previous, my lord, second appeal, High Court said you frame a issue, find out that whether the suit is maintainable, my lord, for non-joinder of the necessary parties or the co-sharer of the suit.
Where is that?
Now, my lord,
Where is that order?
Page-
Order?
page 80, your lordship.
80.
It is the admitted fact, page 80, your lordship will find. This is the High Court order. The first you do this, and thereafter you will go to other aspects of the matter.
Trial court order. Trial court.
No, in the High Court, my lord, it has been mentioned in this particular order. In this trial court judgment, there is a mention of the High Court's, my lord, order. The suit for declaration of title and partition by issuing a preliminary decree. Aftermath of trial, the suit was decreed in favor of the plaintiff. Now it has been dismissed. Earlier it was decreed in favor of the plaintiff respondent. So other side had to come. Having been agreed, the defendants preferred an appeal before the Honorable High Court in RFA number 87 of 2003, in which an issue was framed whether the plaintiff's suit is maintainable in its present form.
Final order passing RFA 87. RFA
87 of 2003, your lords.
See.
And accordingly, my lord, the suit was remanded back. And after remand, my lord, this judgment was passed. This is the second round, my lord. In earlier, my lord, the decree passed by the learned court, entire 32 bighas of the suit lands were given in share of the plaintiff's, your lordship, leaving nothing for the defendants, although they are the co-sharers of the suit land. And that's why, my lord, we had to come. And court says, no, not in this way. Yeah, there is a judgment. Firstly, everybody's share is to be ascertained, order 2018, and then you decide this issue. When admittedly so many people were left out. Now, court has given a finding, yes, some of the co-sharers, they are not before the court. Behind their back, I cannot pass a decree. Your suit is bad for non-joinder of necessary parties. The suit is not maintainable in the present suit. You do one thing, court was asking the plaintiff, you withdraw your suit, file a fresh suit. Nothing was done by the plaintiff. No prayer has been made for impleading the parties who were left out, they filed the appeal. And appeals court said the time is now over. My lord, in this judgment, 1965 Judgment 271, your lordship may see that judgment, your lordship, for the time being, my lord. School बोल रहे हो हमको में लगे से लेकिन देखिए मैं भूया भूया इसमें paragraph 15 of the judgment here also may kindly see my paragraph 15, my lord, it is unfortunate that the appellant's claim has to be rejected on the ground that she failed to include her two brothers to her suit. Though on the merits we have found that the property claimed by her in her present suit belongs to her mother, and she is one of the three heirs on whom the said property devolves by succession under section 7 of the Act. That in fact is the conclusion which trial court had reached, and yet no action was taken by the appellant to bring necessary parties on the record. It is true that under Order 1, Rule 9 of the Code of Civil Procedure, no suit shall be defeated by reason of misjoinder or non-joinder of the parties, but there can be no doubt that if the parties who are not joined are not only proper but also necessary parties to each, the infirmity in the suit is bound to be fatal. Even in some cases, the court can, under Order 1, Rule 10, Sub-Rule 2, direct necessary parties to be joined, but all these can and should be done at the stage of trial. and that too without prejudice to the state party's plea of limitation. Once it is held that the appellant's two brothers are co-sharers with her in respect of properties left intestate by her mother, the present suit filed by the appellant partakes to the character of a suit for partition, and in such a suit, clearly the appellant alone would not be entitled to claim any relief against the respondent. The estate can be represented only when all the three heirs are before the court. If the appellant persisted in proceedings with the suit on the basis that she was exclusively innocent, she took the risk, and now it is too late to allow her to rectify the mistake. This is the judgment, my lord, 1965, year 1965, Supreme Court, my lord, case 27, my lord, for Kamal versus the legal daughter.
Yes.
Huh? This is from right. What are the line? Same judgment here also by mistake. Same judgment.
Same judgment, you are given it.
Same thing. So my only submission is, my lord, that let the learned court below decide the, my lord, maintainability of the suit. Because, my lord, this appeal is a continuation of the suit. So,
This is not, we can't agree to it. There is a reason for that.
and thereafter, my lord,
We'll tell you why not. We'll tell you why not. That is why this order of the, this first appeal was necessary. In this first appeal order of RFA 87 of
Yes.
2003.
yes, your lord, there is a man.
Yes.
Yes.
Now here what has happened,
There, my lord, precisely said who are not the parties, who are the parties, who are not the
no, that was not.
parties. If I remember, my lord, I was also the.
You were the counsel here, but that's not the fact. In this case, that is why this was not there and we wanted this order. Here what had happened was, as per the pleadings, there were 8 issues. First is whether there is cause of action. Number 2, whether it is barred by any law of adverse position. 3, whether the suit is bad for non-joinder and misjoinder and non-joinder of necessary parties. 4, barred by res judicata. 5, have the plaintiffs acquired any right, title, and interest within the sale deed 6162. 6, whether the plaintiff has got right, title, and interest over 32 bigha, 7 kata, 14 chatak, so and so land. 7, whether the plaintiffs are entitled to preliminary decree. 8, to what reliefs the plaintiffs are entitled to. Out of these issues, the first appellate court made a discussion and then arrived at a finding that issue numbers 5, 6, and 7 are unnecessary. And therefore, instead of that, the first appellate court says whether the plaintiff's suit is maintainable in its present form. That is to
Additional
be
issue,
shown.
my lord, whether suit is maintainable in its present form. Page
So you see,
85.
so you see, there is a judgment of this court.
Page 85, my lord, of the present judgment, my lord, in the title.
That doesn't
my lord,
take you
after
anywhere.
remand.
That doesn't take you anywhere, Mr.
Here,
Gaur.
my lord, page 84, my lord.
You are avoiding the question. You see, I am putting your question, you are avoiding it. The question is, when the High Court gives a direction to decide an issue of whether the suit is maintainable in present form, the issue of non-joinder cannot be taken up. Non-joinder is
Maintainability, my lord,
is a-
non-joinder, misjoinder, these
That is
are,
already
my
an
lord,
issue here.
basically, these are maintainabilities of the suit.
we
your
don't
lord.
know, but this was issue number 4.
Without impleading the, my lord, necessary party, suit cannot be proceeded with, it is, my lord, not maintainable, your lord.
No, the reason is,
No, my lord, now
This-
your lordship,
this
for
first
the
appellate
time
court-
being, my lord, for a
this
moment,
first
my lord,
appellate court gave a finding that this Abdul Rashid Barbhuya and Abdul Bari Barbhuya were impleaded defendant in the earlier suit.
my lord,
And now there's a finding here that they have already been given a separate
No,
pata.
for a moment, my lord, page 84 of the present petition, my lord, what are the issues, my lord? What are the issues? Your lordship has read that, firstly, my lord, whether there is a cause of action for the suit, whether the suit is brought by law of adverse possession, whether the suit is bad for misjoinder and non-joinder of necessary parties,
Yes.
That is what the learned trial court has decided, my lord, in paragraph 6 of the present
That
judgment. of the
finding was
trial
not
court.
set aside.
Then, my lord, whether the suit is barred by the law of res judicata in view of then so and so, and then whether the plaintiff has acquired right title and interest in the suit land, so and so, whether the plaintiff has right title interest, whether preliminary decree to what relief, and then additional issue, whether the suit is maintainable in its present form. So in
So
the
see,
suit,
out of
my
these
lord,
issues-
both the things were there.
Out of these issues, 3 were already struck off by the High Court. 5, 6, and 7 were struck off. Instead, it says frame the additional issue of maintainability and then decide.
Additional issue was there, court said.
Look at the finding, that finding was not interfered.
Court said that it is not maintainable, due to, my lord, non-joinder of necessary parties.
No, that doesn't say so.
My lord, paragraph 6, my lord, of the trial
That
court.
is why you see, I don't rely on that paragraph 6. I am relying on the judgment where this order observation is there.
Of the High Court, my lord. Earlier,
Yes, that's why we have got a printout.
High Court, whatever, my lord, High Court has given, now the trial court has given a judgment. Now, whether it is wrong or right, my lord, it is to be decided first by the, my submission is that it is to be decided first by the, first, my lord, at first by the learned appellate court below in accordance with the law, my lord. Then other things will be decided by the learned lower appellate court if it desires your law. Or on the threshold, my lord, if it is not maintainable, then it is to be dismissed. So that's why, my lord, maintainability is a question of maintainability or jurisdiction or otherwise things just somehow. These are to be decided, my lord, as a preliminary issue. Here it was not decided in preliminary issue. Court has gone into the details. All of the issues has been decided by the trial court. It's all right, my lord. Now, thing is that in a summarized manner, only thing, my lord, it is to be seen that whether the suit filed by the respondent plaintiff is maintainable. Trial court had said, no, it is not maintainable. Now, my lord, learned appellate court below is to give a judgment on that. We do not know whether it may be, my lord, research that way court may say, no, it is not bad for or maintainable. Court may say the suit is maintainable. It is not bad for non-joiner, or court may
Yes,
say otherwise.
Mr. Rajchowdhury, what you are saying?
Me, it is your lordship. My lord, I am the plaintiff in the suit. My lord, my suit was for partition. It was decreed in my favor. They went for an RFA. That RFA was, your lordship has just got it, the judgments. Some issues were struck off and others it was sent. Then the trial court decided the issue. It went against me. Page 95, para 12 of the trial court judgment, para 12 and 13. Page 95, para 12 and para 13. These are the findings of the trial court, against which I came for a RFA before this Honorable Gauhati High Court. But because of the pecuniary jurisdiction, that was the order passed, where in the RFA I filed an application under Order 41, Rule 27. And it, because of the pecuniary jurisdiction, it was sent to the trial court, first appellate court over there. And at the stage of final hearing, my application was heard and the judgment is passed at 123. Under Order 41, Rule 27, against which they have come before this court. And they want to say this, the appellate court, because this is a continuation of the suit, should have decided the maintainability, then the Order 41 Rule 27. And my lord, this application, we are not bringing any documents. We are arithmetically bringing them shares. And my lord, after Ibrahim Ali, that 2012, 2015, there is a judgment, 2019, there is a judgment. In 2022, my lord, this judgment has come of Justice Pardiwal and Justice B.V. Nagaratna. And now Order 41, Rule 27, it starts at para 6, my lord, para 7 onwards. Para 7 onwards. Para 7. Yes. This is the concept, my lord. There is no wrong in allowing this, my lord, at the final stage of the year of the appellate court. Now only because he has not decided the maintainability of the suit, which was earlier decided by the High Court and remanded back. The trial court has decided that issue. Now we are against that trial court judgment in an appeal. In the appellate forum, my lord, we have filed an application order 41/27. And this application has been decided prior to the final stage. At the final stage. See, this is the what my lord, this argument that maintainability has to be decided first prior to order 41/27. And we are not bringing any documents. We are bringing only the arithmetical shares over there. Para 8 is also, my lord, it has decided that 15 judgment. And para 11, that 18 KNSSC judgment has been decided. And the finding of the trial court at page 128. And no argument is placed on this order that it is bad in law. Page 128. Only argument is this, earlier RFA was there, so appeal is a continuation of a suit, maintainability has to be decided. But they have come against the order of order 41/27. One 128 last paragraph. Page 129, last paragraph is also there, man.
You have filed you have filed one suit or two suit? Only one suit.
One suit. Earlier it was decreed in my favor, then my lord, RFA, it was sent back. My lord, some issues were struck off, some issues were left. The trial court again dismissed my suit. I came for an appeal before the High Court. Pecuniary during that appellate forum, I filed an application, Order 41, Rule 27, in your lordship judgment, to hear the application of the final stage on basis of the 2012 judgment. During the pecuniary jurisdiction remanded back, it went to the trial appellate court there in the district judge, before the district judge, where it was held, and ultimately final hearing this Order 41, Rule 27. And the whole argument of my senior friend is that maintainability has to be decided first. That is the case.
Anything in reply, Mr.
My lord, in this connection, my lord, another judgment, my lord, your lordship will kindly peruse, my lord, this paragraph 21 of the Apex Court judgment, your lordship. And your lordship will also see, my lord, in the judgment passed by the learned trial court, your lordship. All this evidence or whatever it is, my lord, what they like to adduce that additional evidence, these are already there in the judgment of the, my lord, trial court, my. Paragraph 21, your lordship.
First. Mr. N. Bharat, and counsel for the petitioner.
And my lord, page 81 of the judgment, my lord, all this were there in the court below, no additional, my lord, our objection was also in that way, that all these evidences which are now, they desire to adduce that the additional evidence are already there in the case record, your lord. So this is, my lord, just to delay the disposal of the, my lord, appeal of the suit, your lord. Nothing more than that, your lord.
Counsel for the petitioner. Also heard Mr. P. K. Roy Chaudhary saying also assisted by Mr. M. H. Laskar, learned counsel for the, you're appearing for whom?
All the respondents.
For all the respondents.
All
The respondents. Next. This matter has a this by filing this application under Article 227 of the Constitution of India, the petitioners who are the defendant in the suit, your defendant numbers,
defendant number. 1, 2. এটা বল। One, two, three. I am the plaintiff, madam. I am the plaintiff.
no, the petitioners are defendant numbers, which defendants in the suit? Just try to find out who is the respondents. Their defendant numbers.
Petition and now what I find, my friend is saying the names were there, which were there in the suit. Maximum of the, those have expired.
No, you see, that's not the way. Here, the petitioner number one is Moizuddin Barbuya on death of Abdul Rauf Barbuya. So we must get Abdul Rauf Barbuya somewhere. At least I am there till 2:35, I am not getting it. Who is this Abdul Rauf Barbuya?
Defendant number 10, man. My friend is saying defendant number 10.
Defendant number 10.
Abdul Rauf is there.
No,
Son of late Ghulam Rawani Barbuya.
we don't know.
Alive.
Muhammad Abdul Rauf. Abdul Rauf may be Barbuya, may not be Barbuya. We
He was
don't know.
son of Ghulam Rawani Barbuya.
That's not how I am finding it. It must match.
They are the petitioner there.
We have been dealing with foreigners traveler for quite long. We and Barbuya must match. It's not there. So, okay, this number one we are not getting. Then number two is Masman Ali Barbuya. Masman is 11. 11. Then number 3, Mahibur Rahman. Mahibur is 12. Then Anam Uddin Barbuya. He is 13. Then 5 is Askar Uddin Barbuya.
15.
Askar 15 is 15. Zakira Barbuya.
Zakaria,
16. 7 is Karimul Islam Barbuya. 17.
18.
Moizul 18. The petitioners, public substituted petitioners number 11 to 18. Sorry, these numbers 2 to 8 are shown here. In respect of the substituted petitioners of the petitioner number 1, it is presumed that they are the legal representatives of defendant number 10, Mr. Hawa. As per the plaint, the defendant number 10 is Muhammad Abdul Rauf and not Muhammad Abdul Rauf Barbuya. The petitioners have assailed the order dated 10/7/2024 passed by the learned additional district judge, Hailakandi, in BGA case number 13 of 2024 in TA number 3 of 2022 by the said order notwithstanding objection as to the non-gender or necessary parties, comma, the respondent numbers now plaintiffs is, who is the plaintiffs? So, Rajat,
Page 24.
no, no, all of you are plaintiffs.
Plaintiff. Legal heirs of the plaintiff.
Only the plaintiffs, nobody else.
No.
Okay. Are the plaintiffs of the substituted plaintiffs were allowed to read additional evidence as contemplated under Order 21, Rule 27 within bracket B of the CPC law. Next. The learned counsel for the petitioner has submitted that as the suit was dismissed on the ground of non-gender unnecessary.
With your lordship permission, my lord, one judgment has been left of it to alone, like to some.
Pass it on.
Paragraph 21, regarding my lord additional evidence, how it is adduced of this court, my lord, what I. Yes,
It was dismissed from non-gender unnecessary parties and the said objection being taken again in the first appellate stage,
Fill up.
comma, the learned first appellate court, comma, instead of deciding the preliminary issue, comma, having allowed additional evidence to be recorded, comma, is stated to be not in accordance with law. Next one, it is further submitted that the suit was decreed and thereupon the petitioners made a challenge before this court and this court by judgment passed in RFA 87 of 2003, apart from other issues, directed a further issue as to whether the plaintiff's suit is maintainable in its present form, be framed and the matter and the entire suit be decided again. Accordingly, on remand, the proceedings of title suit number 13 of 1997 was decided by judgment and order dated 5/9/2026, 2016. Dismissing the suit on non-gender of what are the four names I state? Four names. Certain persons were not joined as defendants, though they were co-sharers to the suit land. Accordingly, in paragraph 6 of the judgment passed by the learned trial court, it was observed that in the present suit, Abdul Rashid and Abdul Bari Borbhia were brothers and concerned with 20 bigha, 7 katha, 10 gonda land within bracket exhibit 6, and Saibur Rahman Borbhia, Saibur Rahman Borbhia, and Sophia Begum were not parties to the suit, and they were co-sharers of the suit land. And accordingly, they were held to be necessary parties in the suit. Which is held to be fatal. So accordingly, it was held that it would be wrong to assess at this juncture that the plaintiffs have acquired any right, title, and interest over the suit, the land of suit patas. And by holding that preliminary decree under Order 20 Rule 18 CPC needs to be specific not only to the share of the plaintiffs but the share of others co-sharers. And accordingly, answering the additional issue in the negative. Dismiss the suit for partition. For the, it may be mentioned that the issues framed in the said suit were as follows: page 84, 85, additional issues, 9 minutes. Next, in view of the nature of challenge made in this revision, it is not deemed necessary to discuss all the issues as decided by the learned trial court. Next paragraph. In the proceedings of against the judgment decree passed in the decree of dismissal passed in the suit, initially RFA 63 or 2016 was preferred. And in connection with the appeal, an application was filed under Order 41, Rule 27, related with Section 151 CPC, for allowing the applicants to adduce evidence for bringing on record the specific shares of the contesting defendants. So the same was registered as Ms. J case number 13 of 2024, arising out of IA Civil 3379 of 2018 in RFA 63 of 2016. This court by an order dated 19/7/2018 passed in the proceedings of RFA 63 of 2016, observed that the said application shall be considered at the stage of final hearing, allowing objection if any prior to the hearing of the connected appeal. Full stop. In course of time, due to enlargement of pecuniary jurisdiction, the proceedings of RFA 63 of 2016 was transferred for disposal before the Court of Additional District Judge, Hailakandi, where it was registered as Ms. J case number 13, title appeal number 3 of 2022. In connection with this said appeal, application under order 41/27, read with section 121 CTC, was filed, which was registered as Ms. J case number 13 of 2024. Next one. It may be stated that in support of the contention that the preliminary issues were required to be decided first, the learned counsel to the petitioner has cited the case of number one. PR 1965 SC 271, decided by the Constitution Bench of the Supreme Court of India. In this Supreme Court judgment, which is the paragraph we were relying on, that Kanaka Rathanmal, which paragraph?
Of the Supreme Court and one of the Gauhati High Court. Now, first,
No, which paragraph? Yeah, 1965, which paragraph?
1965 paragraph, your lordship, my lord, 15. 15. And another is 21.
2003, 1 SSC 488.
And in other case, my lord,
Abdul Rahman.
yes, that is paragraph 21, your lord.
This is number 2. 2003, 1 SSC 488. In paragraph 15 of the decision of the case of Kanaka Ratan Mal, it has been held that ordinarily a suit shall not be defeated by reason of misjoinder or non-joinder of parties. But in this said case, the appellant, despite being informed that our brothers were not made parties to the suit, persisted in the proceedings, and accordingly it was held that the appellant before the Supreme Court of India had taken a risk and it was too late to allow her to rectify the mistake. As she had seen, as he had ample opportunity to remedying his defect. In the case of, in paragraph 21 of the case of Abdul Rahman, it has been held that a suit can be disposed of on preliminary issues. Accordingly, it is submitted that as non-joinder or necessary parties related to issues of maintainability of the suit, the appeal being an extension of suit should have been ought to have been decided on preliminary issues first. As regards the issue of additional evidence under Order 41 to 27 of the CBC before the first appellate court, the learned counsel for the petitioner cited the case of number 3 and number 4. In this Sanjay Kumar Singh, which is the paragraph?
There are 7 onwards, madam.
7.
7 onwards. 7, 8, 9, and 11.
The case of Sanjay Kumar Singh, again bracket Chopra, it was held that ordinarily the court cannot take any evidence in appeal. And the exception is Order 41 to 27 CPC, which enables the appellate court to take additional evidence in exceptional circumstances. And even and also held that one of the circumstances in which the production of additional evidence under Order 41 to 27 CPC by the appellate court is to be considered is whether or not the appellate court requires the additional evidence so as to enable it to pronounce judgment or any other substantial cause of like nature. In the case of Nawab Burul Islam and others within Packet Supra, it has been held that in a series of decisions of Privy Council and the Supreme Court of India, it has been settled that additional evidence should not be permitted at the appellate stage in order to enable one of the parties to remove certain lacuna in presenting its case at a proper stage and to fill in gaps. Next one. And you had cited which one? You cited something? No.
No, but this, here, the 15 judgment, 19 judgment, and 2012 8 that Ibrahim is also there. That is only at the final stage. But here the para 9 is also clear, my lord.
Which one?
Para 9 of this judgment,
Which one?
this 2022 SKC, para 9, Sanjay Kumar Singh.
2020,
2, this
7 SCC.
7 SCC 247, para 9.
It's for contract from the learn comes for the serial comes for the respondents has submitted that in the application for additional evidence from us, only the share of the respective co-parties were identified. It should only be explanatory in nature, and therefore there was no perversity on part of the learned first appellate court to allow recording of the additional evidence under order 41 rule 27 CPC. Next. It's on the considered opinion of the court. The law relating to additional evidence under orders 41 to 27 CPC has been laid down in the case of Union of India versus Ibrahimuddin and another, within bracket 2012, bracket close 8 SCC 148, equivalent to 2012 within bracket 0 Supreme within bracket SC 465. In said case, it has been laid down that as an exception to the normal rule, additional evidence under order 41 rule 27. No, sorry, the provision of order 41 rule 27 empowers the appellate court to allow a document to be produced and witness to be examined providing that fresh evidence cannot be introduced under this provision at the appellate stage. And if evidence available on record is sufficient for judgment, the provision of order 41 rule 27 cannot be resorted to. First of the conditions that exist for invoking order 41 rule 27 has also been laid down by holding that the appellate, that only if the appellate court requires additional evidence only when evidence taken by the trial court is so imperfect that a satisfactory judgment cannot be passed on that basis. And such evidence can be recorded if additional evidence was required to be taken on record in order to pronounce the judgment or for any other substantial cause. Paragraph 28 to 30, 37 and 41 within bracket as extracted from within bracket 2012 bracket close 0 Supreme SC 465 is extracted below. Next paragraph. According to in the considered opinion of the court, in order to find out whether additional evidence would have been admitted by the learned first appellate court, in view of the ratio laid down in the case of Ibrahimuddin versus State of Union of India versus Ibrahimuddin within bracket Sutra, the learned first appellate court ought to have arrived at a conclusion that the evidence, additional evidence would be required in order to pronounce the judgment, and only on recording of that satisfaction, the provisions of order, additional evidence within the meaning of order 41 rule 27 CPC would have been ordered. Full stop. This court in its order dated 17/9/2018 passed in RFA 63 of 2016. Had considered the application made under Order 41 Rule 27, read with Section 151 CPC. Okay. To reduce additional evidence. So, however, this court had deferred the application for consideration at the stage of final hearing. In the proceedings of Title Appeal number 3 of 2024, there's nothing on record to show that there were any other steps to be taken in the said appeal. And as the appeal was on board of the learned additional district judge, the same was ready for hearing. And the learned first appellate court the learned first, in this case, the learned first appellate court, gave its reasons to allow introduction of additional evidence on the ground that the learned trial court had dismissed the suit, amongst others, on the ground that the plaintiffs had failed to mention specific share of the defendants of the respondents by providing the DAG/Pata number as contemplated under Order 20, Rule 18 CPC. And having noticed that the plaintiffs have been fighting in court for last 27 years, for a minor defect, they were being deprived of any concrete decision from the courts of law. And therefore, by holding that by the intended additional evidence, the plaintiffs are not going to introduce any new fact or evidence or new claim. It was held that the plaintiffs proposing to furnish specific shares of the defendants of the respondents will assist the court in passing the judgment finally, so that neither party will be prejudiced in any manner and the dispute will be resolved finally. Accordingly, in view of the ratio laid down in the case of Ibrahimuddin within bracket Supra, the learned first appellate court was within its rights to admit the application under Order 41 Rule 27 for hearing. Next one. Therefore, in this case, no, not the next. In this case, the plaintiffs have implemented as many as 296 defendants and pro forma defendants. And in the plaint, the shares of the various shareholders are mentioned. Stop. Therefore, the petition for additional evidence under order 41 rule 27 cannot be said to be an application to bring on record any evidence which was hitherto not available before the learned trial court, as it is only proposed to delineate the shares of various land holders. Full stop. Therefore, the application, the order of the learned first appellate court cannot be held to be bad in view of the finding recorded in the case of Sanjay Kumar Singh within bracket Supra, cited by the learned counsel for the petitioner. Stop. Paragraph 7, on which reliance is placed, is extracted below. Next paragraph. From the above observations of the Supreme Court of India, it is noted that where additional evidence sought to be adduced removes the cloud or doubt over the case, and the evidence has a direct and important bearing on the main issue of the suit, interest of justice clearly renders it imperative that it may be allowed to be permitted on record. And therefore, in the present case in hand, as only a clarificatory evidence is sought to be introduced to determine the shares of various sharers of the land, the same appears to be permissible even in the case cited by the learned counsel for the petitioner. In the case of Kanak Rathanmal, in 1960, number 1, probate of a will was obtained. And in the suit file, the concerned respondent numbers 1 and 2 had set up a title in respect of the suit properties. However, the brothers were not joined in the suit, and therefore it was held that the suit was not maintainable for non-joined or necessary parties. She was the concerned appellant. No, the appellant's claim was rejected because she had failed to include her two brothers in the suit. And there were only three legal claimants to the said property. In this case, though 297 defendants are made made defendants, by an additional evidence, it is sought to be projected that all the necessary parties who had who had interest in the suit land were joined. Therefore, the application which is allowed is not found to be contrary to the ratio laid down in the case of Kanak Rathanmal within bracket Supra. Coming to the case of Abdul Rahman within bracket Supra, the said decision is on the point that when a suit can be disposed of on the preliminary issues, ordinarily suit should be decided under on preliminary issues. Full stop. In the suit, all the evidence was before the learned trial court. And therefore, all the issues, all the 9 issues, all the 8 issues and the additional issue number 1 were decided on merit. Therefore, in the constitutional opinion of the court, this principle of deciding an appeal on preliminary issues would not arise under the facts and circumstances of the present case. So the issue which is being raised is whether the suit and the appeal was bad for non-joint or necessary parties. And the learned first appellate court arrived at a finding that the said issue, the additional evidence to that effect would bring clarity on the point. Therefore, as the learned first appellate court had recorded its satisfaction for allowing the additional evidence to be brought under Order 41 Rule 27, this court would be slow in exercise of power under jurisdiction under Article 227 of the Constitution of India to substitute its view on the considered decision of the learned trial court and only learned first appellate court. Resultantly, this revision fails and the same is revision fails and the same is dismissed. The parties will have to bear their own cost. It will take me some time to upload it. By the time it will only be tomorrow. By tomorrow afternoon, we can upload this order. It will take some time to transcribe and sign it. No, item 15.
Your petitioner
Yes.
your petitioner before a lordship is a decree holder. Her husband expired due to electrocution and he filed a suit for compensation. Suit was decreed and in appeal it was affirmed. Then the decree was put to execution, but that execution case was dismissed on the ground that the civil court has no jurisdiction to entertain the suit.
That impugn order is at page 59 and exam 5. Page 59, man. And exam 5. Where is your plane? My. Plane is at page 17. 17. 17. What happened in appeal? Your appeal was allowed. Appeal was allowed. Partly what is, we file appeal, it has enhanced the compensation. And in decree was. You were the appellant. My lord, I am the appellant. I was there. For enhancement of. Enhancement of compensation. Recompense quantum.
Lordship, yes. Because Lordship, this order is wrong. I have carried the Workmen Compensation Act. So the learned executing court made an error in reading section 19 of the Workmen Compensation Act.
Pardon me, you've not been able to follow you. Please repeat again.
Lordship, the order passed by the learned executing court is wrong and it was wrongly dismissed. The execution cannot be dismissed.
Because you see in your written statement,
Yes.
you take a plea that he was not the employee.
Yes.
And in this order, it says that he is a workman and therefore
Yes.
workman company, that will not come.
Yes.
So you have to set this aside and send it back.
But in otherwise also, the learned trial court and the appellate court said that he was working under the APDCL. So he was a workman under the Workmen Compensation Act. Even in that case also, Lordship, a suit for damages is maintainable.
Yes, sir. Thanks for assisting the court.
Lordship.
Had Mr. N. Hock Leonard, counsel for the petitioner, as well as
R. Bora, Lordship.
R. Borat and standing counsel for the APDCL. Appearing for all the respondents. Yeah, appearing for all the respondents.
Yes. Lordship.
Next. Aggrieved by dismissal of the execution petition by order dated 19/6/2025, passed by the learned civil judge within bracket senior division bracket Elakandi in TX number 4 of 2024, the present application has been filed under Article 227 of the Constitution of India. Next one. The petitioner is the husband, is the wife, what, of Badrul Haq Mazuldar, within brackets, deceased, comma. In the proceedings of TS number 5 of 2014, it was projected that the husband of the petitioner was a workman under a skill category, SKILLED, skill category, who died due to electrocution while working as a muster roll casual worker under Lala Electric Subdivision. At the time of the death, he was stated to be working as a lineman, as a worker, working under the lineman at Vernerpur, VERNERPUR, within bracket, Nunia Khal, NUNIATHAL, that was to repair a fault in the electrical line. He stated to have electrocuted and died on spot. The suit was decreed for a sum of rupees 3 lakh as compensation to be paid within 3 months from the date of passing of the judgment. And on failure, the amount would carry interest at the rate of 6% per annum till realization. The petitioner had preferred an appeal, which was registered as title appeal number 11 of 2022. And the learned additional district judge, Hailakandi, by judgment in order dated 9/10/2023, allowed the appeal and applying the ratio of Sarla Verma and others versus Delhi Transport Corporation and another, 2000, within bracket 2009, bracket 6 SSC 121. Taking into consideration the daily wage of rupees 291, that was the wages for a skilled worker on daily basis, monthly wages was calculated at this 8730, and accordingly, under the principles of the case of Sarla Verma within bracket Supra, the compensation amount was enhanced to rupees 13,39,500 with interest payable at the rate of 6% per annum with effect from 5/5/2013 till realization. Next member. The decreed amount as ordered by the first appellate court was not paid, and accordingly the petitioner had filed an execution petition before the Court of Learned civil judge within bracket senior division bracket was Hailakandi, was registered as T of XEX 4 of 2024. And on the ground that the case of the petitioners was, the plaintiff was that the death occurred due to while working as as workman in course of employment, comma, it was held that the plaintiff could have approached the commissioner under the Workmen's Compensation Act or before the State Administrative Tribunal or the High Court under Article 56 of the Constitution of India. Accordingly, it was held that the suit for compensation was barred under Section 9 of the CPC, read with Section 19 within bracket 2 of the Workmen's Compensation Act. And accordingly, holding that the agreement between the parties to pursue the suit was not sustainable in view of Section 28 of the Contract Act. Would not confer jurisdiction on the court. The execution petition was dismissed. Next one. The direct counsel for the respondent has made his submissions in support of the impugn order. Next one. However, from the contents of the written statement filed by the respondents, they say that they have denied any contractual relationship between the APDCL and the deceased. Whereas the case of the plaintiff is that petitioner was, the husband of the petitioner was working as a workman under skilled category under the APDCL. Therefore, court does not find any admission on part of the respondents admitting that the deceased was their workmate. Under such circumstances, the finding by the moment that they ran the exhibiting court that the petitioner ought to have approached the workmen's commissioner, the commissioner of workmen's compensation is not found sustainable. Similarly, state administrative tribunal would not have jurisdiction to pass any order for compensation on account of death. Often, person claimed to be working under the APDCL. Which is not under the administrative, which is not under the authority of the Assam Administrative Tribunal. Similarly, this court under Article 226 of the Constitution of India does not adjudicate issue of compensation, as this court may award compensation under Article 226 of the Constitution of India only as a palliative, but not as substantial, not on substantial justification. And therefore, when a palliative compensation is paid, all the parties are usually relegated to the civil court. This one. Therefore, comma. Workers' compensation. Yes. Employees' compensation act.
I have a copy of that. Section 3, subsection 5, Your Lordship, read with section 19. Section 3, subsection 5, and read with section 19.
Next paragraph. The provisions of subsection 5 of section 3 and section 19 of the Employees Compensation Act, 1923 are quoted below. The provision of subsection 5 of section 3 of the Employees Compensation Act do not bar the jurisdiction of a civil court for damages, as indicated above, the in this case, the projected employer, i.e. the APDCL, had not admitted that the deceased was the workman, it cannot be said that there would be an ouster of jurisdiction of civil court by applying the provision of section 19 within bracket 2 of the Employees Compensation Act, 1923. Next paragraph. We have above. The court is of the considered opinion that the order dated 19/6/2025, thereby dismissing the proceedings of title execution case number 4 of 2024 is not sustainable. Full stop. Accordingly, the said order dated 19/6/2025 is hereby set aside and quashed. Next paragraph. Resultantly, the proceedings of title execution case number 4 of 2024 is restored to file of the learned civil judge within bracket senior division, bracket was Hailakandi. Next paragraph. As the petitioners and the respondents are both, the petitioner and the respondents are both represented to the learned counsel, both sides are directed to appear before the Court of Learned Civil Judge within bracket senior division, bracket was Hailakandi, on 8th of June. We'll get 1 month time.
Good.
8/6/2026. Next one. When we request the learned standing counsel for the APDC to transmit a download copy of this order and send it to the respondent authorities, in the interest of justice, the petitioner is also directed to produce a certified copy of the order before the office of the general manager, Barakgori zone, APDCL of Meherpur, Masvincher. Bring the order to the notice of the said authority. This general manager would be okay?
Not sure. Or otherwise the subdivision engineer can,
Subdivision engineer.
Yes,
Okay,
we
then
can go to that.
subdivision engineer, APDCL, Lala electrical subdivision, Lala, within bracket, respondent number 7. Bring the order to the notice of the said authority instead of that. Application stands above to the extent as indicated above. There will be no others to cost.
that's all right.
Your book. Come on. I'm sorry, there's a VC with huh? There's a division bench with like price. No.
For delivery of judgment, WP Criminal 8/2026.
This petition is allowed in the impugn order of detention. So we'll have to look at it. Detention order. Acha, this the extension order is also under challenge, right? You are getting our voice at
Not very audible, not much audible, my lord.
not audible.
No, one, two.
You're getting the voice now? Getting the voice?
Yes, my lord.
You're getting the voice?
Yes, yes, now I can hear.
Okay. The writ petition is allowed and the impugn orders are set aside and the detainee Henkao Lord Jem is required to be released forthwith if not otherwise required to be detained in connection with any other case. The records of detention proceeding being filed with number so and so of the Home Department Political Branch be returned to the learned government advocate.
Deeply obliged, my lord.
Kindly inform Ms. Inaholi Watso. She is
Yes,
not
ma'am.
there.
Yes, my lord. Highly obliged, my lord. Highly obliged.
Courtmaster at Kohima. Yes, kindly inform Ms. Inaholi Watsa also, government advocate.
Yes, Lordship.
Will be return the file.
Yes, Lordship.
Obliged, my lord.